Yes.
Today, we had some difficulty, so I pray for next week.
You are for?
For the petitioner, also.
Heard, Mr.
D. Gogol.
D. Gogoi. And the counsel for the petitioner who prays for an adjournment on the ground of personal difficulty. Also, an additional public prosecutor. Miss A. Begum, who does not have any objection to declare, hence declare it allowed. Let this matter be fixed after it.
There is an interim order, may be.
The interim order shall continue.
Highly obliged.
Appraisal Lordship. Lordship, back to mention item number 22. Lordship, CD not received.
Item 22, CD is there.
Okay.
It is there. কই বলো?
Next date may be fixed.
We'll take it up.
Okay, Lordship.
May I please say, Lordship? Lordship, I beg to mention item number
এর
16.
জন্য কইলেন।
Lordship, from this FIR, one petition has been dismissed, Honorable Justice P.J. Shoikia. So matter may be listed before this Honorable.
Heard, Mr.
On
What is your name?
Yanuddin,
M. Enuddin, learned counsel for the petitioner,
one third.
who supports that another anticipatory bail application arising out of same police station case number has been taken up and disposed of by a coordinate bench of this court. Hence, according to prevailing notification, he prays that this case may also be taken up by the same bench. Stop. Considering the submissions made by learned counsel, the registry is
Lordship,
directed
kindly
to,
date may be.
registry is directed to list the matter before appropriate bench.
Lordship, I am not interim. I am not on interim.
Registry pray before registry.
Same bench of the.
May it please your Lordship. Lordship, I beg to mention item number 19, Lordship. This matter may be adjourned for the day, Lordship.
Is there is
Case there is
Lordship.
receipt, Lordship.
Why?
Lordship, Mr. Kaburia will appear in this matter, but he is outstation, Lordship.
Heard, Mr.
M. Alam, Lordship.
M. Alam, learned counsel for the petitioner,
CD to be written, Lordship.
who prays for an adjournment as the conducting counsel, Mr. K. Burwa, is out of station. Considering the submission made by learned counsel for the petitioner, the prayer is allowed. Prayer is allowed. Let this make. When can we fix it?
Lordship, 14, Lordship.
Let this matter be listed again on 14th of November. The case diary which is available before the court shall be retained till next day.
Highly obliged,
The
Lordship.
calendar to Yate Law. Yat case. This outbreak. On last two occasions, also nobody was there.
Lordship.
None has appeared for the petitioner when the matter was called. Let this matter be listed again on 14th of November. Okay.
CD কত?
None has appeared for the petitioner. List this matter again on 14th of November.
Lordship, my senior is on her legs. Kindly pass over a matter for a time being.
Isot Mati.
Is it? Is it?
May it please your lordship. My lord, the impugn order is at page 69. My lord, I am the owner of the coal. I have all the invoices and vouchers and the to show that I am the bona fide purchaser of that coal. Now, the learned court below has granted Jimma to the government agency saying that the coal is perishable. My case is that since I have the primary and these documents of ownership and all has not been considered by the learned court below, my lord. As many as my lord, I have annexed all the Annexure 12 series is my document. I have made a compilation, your lordship may continue.
No, but the Jimma is given to Coal India Limited.
No polling.
Not coal India, my lord, geology department.
Geology.
These are the, my lord, my invoices of the purchase of the coal. Amount I have given, quantity I have given.
You have not challenged that out.
We have challenged.
The order by which the Jimma was given by to
Yes, my lord. Annexure 16, sorry.
page.
Page, my lord, it will start at 71.
Yes.
Now they are trying to auction it, my lord. For the time being, my lord, for a short date, my lord, the auction may kindly be stayed, my lord.
These are national property, my lord, and court has already considered all those things after perusing the documents, my lord.
The whole seizure itself is illegal. And secondly, my lord, what they have done, my lord, they have sealed the property
No,
in a notice also.
what is the offense? Where is the FIR
Yes.
against?
The lordship will find the FIR at page, just give it, 36. It starts from page 36. The relevant portion your lordship will find at page 39. Then the seizure is at page 41.
Please read the FIR.
Yes, ma'am. It's a short FIR at page 39. I'm directed to inform you that on 16 July 2024, 2 numbers of coal depots in Lal Pahar area under your jurisdiction have been sealed by the district administration. We gave the higher charges and we unloaded the coal in the depot belonging to someone else, ma'am. And and subsequently handed to the undersigned white letter number so and so, details of which are attached in a separate sheet with this letter. The custody of the above mentioned sealed coal is hereby handed over to you. In this connection, the FIR is lost. And your lordship will find the case has been registered under section 303241 capital A 21/3 so and so. So we'll investigate the case. Then the seizure is at page.
What is 303?
But earlier IPC 379.
Okay, but there is no allegation of theft.
No. Well, there's some ego issues between some officials and this owner of the coal, my lord. I need not elaborate. My lord, your lordship, since now the coal is lying there and they are planning to auction. If they auction, my lord, my whole exercise will be.
No, you will get the
No, my lord, I may get a
Yes,
better price than the auction. My lord, the auction, my lord, their government has no interest, my lord.
My lord, may kindly peruse page 73.
Yes.
And they are also allowed to sell the seized coal to auction and deposit the amount in government treasury.
ultimately, if you are found to be owner, proceed will go to you.
No, no, my lord, the auction money is, my lord, they will not get the, I will not get the market value, my lord. Auction is, my lord, this coal is lying there for quite some time. I will not get the original market value, my lord.
My lord, and the thing is that the fixed 30/10/24 for compliance report. What happened on 30/10? I don't.
And it's not that the coal is lying somewhere else. It's inside my premises, my lord.
We don't know whether coal has been auctioned or not in the
It's
meanwhile.
not been auctioned. My lord, your lordship can record my statement and can protecting me in the interim. If in the meantime it has not been auctioned, my lord, then your lordship will fix a short.
No,
For
what is your ground for challenging this order?
Well, this whole process of seizure is illegal because this is not a theft coal. This is, I have my bona fide purchaser of the coal. I have given all my invoices, challans, everything. How can they say that it's my coal lying inside my property as theft property, my lord?
In
Who is the victim here, my lord?
whose land this coal is lying?
My lord, it was taken on lease. I have given those particulars.
It is still lying in that.
Yes, yes. And they have sealed the premises. And what we do, my lord, this seized coal, what we do, we process it into coke
Where?
in our premises, not outside.
My proprietorship.
But is it dangerous to keep it open?
No, no, no.
Because this is open
No, this is open area, my lord, not, it doesn't cause any pollutions or not. That is not the
Then how
allegation.
it is perishable?
Perishable because, my lord, with rain, water and all the value, means the heat capacity will go because I have to convert it into coke, my lord. That heat capacity of that generation of that coal will decrease. I can show your lordship from each and every document from page 1. But today, my lord, since it is the first day, your lordship will call for the scan copy of the records.
Case diary would be required.
Yes,
Right.
yes, yes.
And my lord, I
Uh,
objected to the
Where, no, in the meanwhile, where are the documents to show your ownership?
Yes, my lord. Annexure 12 series, my lord. I have given the compilation of that invoices in that single paper, but it starts from page 42.
Now, where is the statement in your petition that you have purchased?
Yes, madam. Wait, just a moment. Yeah, ma'am. Paragraph number 7. Page 8, madam. There are 7, 8, 9, 10 are sequence.
Bill series is that page?
Well, page 42 it starts, my lord.
How much coal is there? Is
My lord, 308.14 quantity in ton. Your lordship, there may be my lord, exact weight to unless we put it in the truck, we don't get it. But but we have given receipt for 308.24.
Mr. B.D. Kumar, Lanel,
may kindly peruse page 34.
page 34. No, in the impugn order, the question of ownership is not discussed.
No, sir.
Yes. What is there?
But 34 is the notice given to the landowner. To me, my coal has been seized, no seizure list has been given. I have given a categorical statement also.
Whether any license is required to, any permission?
We have all this statutory license, my lord.
For
Yes, yes.
storing coal,
Yes, yes, my lord. We have annexed it, my lord.
where?
My lord, your lordship will find,
No.
your lordship will
What,
just,
what is 34 notice?
34 is the notice to the landowner, my lord. Your lordship will just look into, but I'll not take your lordship's mercy. Your lordship will kindly look at the index to this petition, my lord, what I have annexed, my lord.
My lord, obviously,
Please,
my lord,
I-
will go to
I-
landowner.
Yes.
By this 34 notice,
Yes,
you were asked to show this.
I have given a so-called reply also, because no seizure list was given. I have given a so-called reply also. Your lordship will kindly look into the documents that I have annexed with this writ petition in the index itself. Your lordship will find. Annexure 1, I have given the GST registration, my lord. Your lordship will find. Then the Annexure 2 is the authorization issued by the landowner. Annexure 3 is the NOC from Lalpahar Village Panchayat. Annexure 4 is the NOC from Lekhaponi Gaon Panchayat, my lord. Then Annexure 5 is consent to establish from Pollution Control Board, my lord. Then I have also given Annexure 6, the license from Lekhaponi Gaon Panchayat. Then the certification of the Assam government, which is required under the Assam Shops and Establishment Act, I have given. So all the certificates that are required is not that I don't have the statutory certificate, it's not the allegation. But you also will see from page 34 was given it.
No, then what is the allegation?
Allegation, my lord, they suspect it to be stolen, my lord. But they must say from during this, probably they have made some investigation.
But there is no such mention in the FIR
No.
that it is stolen. No, allegation is not there. FIR does not disclose any offense.
My lord, first the seizure, then the FIR, your lordship will see. First the seizure, then the
No,
FIR.
still, even if FIR is subsequent,
Yes, my lord.
FIR should have disclosed the
At
offense.
least the minimum, to set the motion. So I was trying to not to waste precious judicial time of this court. That's why initially I said that your lordship will call for the case diary and
Heard Mr. B.D. Kumar, learned counsel for the learned senior counsel assisted by Mr.
H. Agarwal.
H. Agarwal, learned counsel for the petitioner. Also heard Mr. R. Kaushik, learned additional for the prosecutor. This application under section 528 of PNSS, 2023 has been filed by the petitioner, namely Muhammad Tahzib, impugning the order dated
both the orders, my lord.
27/9/2024 as well as 4/10/2024, whereby the $308.14 ton of coal, which is claimed to be the property of the petitioner, has been given in custody of the whose custody it is given.
My lord, your lordship will find in the respondent number 2.
Custody of respondent number 2, and the prayer for giving Jimma of the same to the petitioner has been rejected. So, senior counsel for the petitioner has submitted the petitioner is the proprietor of Lal Pahar Coal Depot in Tinsukia, Assam, and operate a lawful business of coal processing and distribution with requisite statutory licenses and authorization, including GST registration and NOC from local authority. It is submitted that on 15/7/2000 and where is that notice?
Page 33.
15/7/2024, the subdivisional officer within brackets civil Margarita had sealed the petitioner's coal depot without prior notice, and subsequently an FIR was lodged against the petitioner under section 304 within bracket 2 read with section 4(1)(a) of which
4 MMRD, madam, minerals and mines and mineral Regulation,
41A of Mines and Minerals.
Regulation of Development Act
Regulation of
1957.
Development Act 1957.
It also has read with section 3 of Prevention of Damage to Public Property Act 1984.
Read with section 3 of
Prevention of Damage to Public
Prevention
Property.
of Damage to Public Property Act 1954. Stop. Learned counsel for the petitioner has submitted that the FIR discloses no offense against the petitioner, though it has been registered under aforementioned section of law. It is also submitted that the petitioner has purchased the aforesaid coal from one Wangshu Enterprise, and to that effect, he has annexed all the invoices of purchase of the said coal along with his petition as annexure 12 series. The learned counsel for the petitioner has also submitted that the by the impugn order, the respondent number 2 has been directed to sell the seized coal by auction. And where is that order?
Page 73. Operative portion is that page 73. Last paragraph.
To auction and deposit the proceeds in the government reserve. Learned senior counsel for the petitioner has submitted that while passing the impugn order, the court below has ignored the fact that the petitioner is the lawful purchaser of the seized coal, and the coal and the said coal has been seized and sealed without affording any opportunity to the petitioner to.
Your lordship will also look into my prayer at page 18. They have sealed, and today I'm not saying that your lordship will direct them, but your lordship will see they can't seal a immovable property.
Learned counsel for the petitioner has prayed for submitted that if the coal which belongs to the petitioner is sold by auction, he would suffer huge financial loss, and therefore prays for stay of the auction of the seized property. On the other hand, learned additional public prosecutor has submitted that perusal of the case diary would be necessary. He has also vehemently opposed grant of any interim stay in the meanwhile. Stop.
Lordship, in page 72, perhaps earlier also, there is a paragraph. On such perusal, it appears that the IO of the instant case earlier prayed for demand of the coal given to the NECF
Page number
72.
They could not even ensure that transport also, your lordship.
NECF CIL Margarita, however, even after prayer being allowed by this court.
no, but
Yeah.
when FIR does not disclose anything,
I am saying that, my lord, because maybe there was an order earlier granting Zimma to the IO to hand over those coal to the NECL and coal in the limited, my lord.
Ultimately, it did not
Materialize.
materialize because they could not ensure transport, my lord. So that's why it was
Then
given to the
geology
geology
department
department was given, and the geology department also till now could not auction it. I have nothing to hide, my lord.
now let us peruse the case.
Yes. They will-
The, in the Stop. Considering the nature of the, considering the rival submissions of the Senate counsel for both the sides, perusal of the case diary is felt necessary. Hence, call for the case diary. Stop.
18 to পিছনে একটা date থাকে। 36%.
আপনি
When
After 18, my lord.
on 21st.
let this case be listed again on
Oh.
21st of
No, no.
November. In the meanwhile, considering the fact that the petitioner has produced the tax invoices for purchase of the coal which has been seized in this case, the the impugn order dated
Twenty-seven, 9/2024. Page 7.
the direction of selling the seized property, seized coal through auction given in the impugn order dated 27/9/2024 shall remain state till next letter.
As well as 410, Malay. If 27 is 10, they will say that 410 has not been stayed, then it will be a complete problem.
No, 4.
Yes, but it is marked, it is marked.
Only,
Yes,
only
I'm obliged, yes. Your lordship is absolutely correct.
release this matter again on
21st,
21st.
we are blessed.
None has appeared for the petitioner on call. Please,
20.
No, this is a 438 application against 3 petitioners.
what is the offense?
Hello. Offense, lordship will find under section 329, 472 and 1091 and 351 35 of the BNS 2023. So what has happened, lordship?
What are the offenses?
Offenses are attempt to murder, lordship,
Okay,
hurt,
grievous hurt.
yes. The allegation is that this,
Where is the affair?
yes, that lordship will find. At page 11 onwards. Annexure 1. May I read, lordship?
Yes.
There are 3 accused persons. With due respect, I beg to state that yesterday on 1/1/2024 at about 8:30 p.m., the above mentioned accused person criminally trespassed into my home with the intention of killing me, hit me on the head with a wooden plank, causing grievous injury. The accused number 1,
What is your name?
Surajit,
Surajit Mosumi and Dipanjali.
yes,
Named.
name. The accused number 1 tried to touch my 13-year-old granddaughter inappropriately, and the accused number 1 even threatened that if I did not hand over my house and property to him, he would kidnap my so-and-so and kill her. As I was busy with my treatment, there is some delay in lodging the affair. No, what has happened, Lordship? These parties, the informant and the petitioners, are engaged in a long-standing land dispute and other affairs being filed against one another. Now, as far as the accused number 2 is concerned, Mosumi Mahanta, he herself is a victim of a POCSO case. Now, what has happened, Lordship? Initially, the POCSO case pertaining to the accused number 2, it was charge sheeted against one of the accused person, one Dipankar De.
Who hit with the wooden plank?
Lordship, who with the Pune magistrate.
Allegation is against the accused number 1.
Where?
Accused number 1
Person.
tried to touch my 13-year-old.
Nah, hitting with this
No.
attempt to murder.
Direct allegation is not there as such.
Yes, there will be.
Even the interim may be what has happened meanwhile, the petitioner number 1, Surajit there, had lodged an FIR, same type of FIR against this informant, Lordship. And in that case, the The informant Dulu Das is one of the parties. The case is charge sheeted, and on 38th, the learned court below, the learned additional session judge number 2, Nagaon, was pleased to frame charge against the informant. That lordship will find that annexure 3, page 37. Informant is one of the accused where Surajit De, the petitioner number 1, lodged an FIR against the informant. That lordship will find at page 37.
Allegations are not so good, Lordship. Let the CDB day, it is AB, Lordship.
There
Short
are
date,
various cases lodged against one another.
it's all right.
There is a land dispute.
We'll call city case diary and fix a short date.
Short date, Lordship.
If not for the accused number 1, may I plead for these two ladies, lordship? Petitioner number 2 and 3.
After 1 week, Lordship.
Okay, no, let the ladies be on interim date. Third, Mr. A. Ganguly, learned counsel for the petitioner. Also heard Ms. A. Begum, learned additional public prosecutor. This application under section 482 of BNSS, 2023 has been filed by the petitioners, namely Surajit A. number 2, Mosumi Mohanto, and Gipanjali Das, who are apprehending their arrest in connection with Nagaon PS case number 1063/2023-24 under section 329 within bracket 4, 117 within bracket 2, 109 within bracket 1, 351 within bracket 2, and 3 within bracket 5 of BNS 2023. The gist of accusation in this case is that one Dulu Das has filed an FIR before the officer in charge of, Itasali town outpost, on 2/11/2024, inter alia, alleging that on 1/1/2024 at about 8:30 p.m. the petitioners, who are named as accused in the FIR, criminally trespassed into the house of the first informant and hit him on his head,
It hurt.
or hit her on her head with a wooden plank, causing grievous injury on her person. It is also alleged in the FIR that the accused number 1 within bracket Surajit De tried to inappropriately touch the victim, thus the daughter of the informant, and also threatened the informant that unless the house and property of the informant is handed over to the petitioners, the petitioner number 1 would kidnap the minor daughter and rape and kill her. Stop. Learned counsel for the petitioner has submitted that the allegations leveled in the FIR against the present petitioner are false. He also submits that prior to this FIR, who lodged an FIR against the
Petitioner number 1.
petitioner number 1 had lodged an FIR against the
Informant and his
Ulu
and her
Das
family members.
and her family members. And on the basis of his FIR, charge sheet investigation was initiated and charge sheet was also laid against the informant and her family members. Stop. It is also submitted by learned counsel for the petitioner that in that case, even charges are framed against the informant Dulu Das and her family members who were shown as accused in the said case. Learned counsel for the petitioner submits that the present FIR has been filed as a counter blast against the case filed by the petitioner number 1 against the informant and her family. So, on the other hand, learned additional public prosecutor submits that perusal of the case diary would be necessary for consideration of the instant anticipatory bail application and praise for calling for of the case diary. Stop. Call for the case diary, fixing
26,
26
11.
11 2024 for case diary. In the meanwhile, considering the submissions made by the learned counsel for the petitioners as discussed herein above, comma, the petitioner number 2 and 3 being women, being female, comma, are allowed to go are grant interim protection during this period. Stop. If before arrival of the case diary, they are arrested in connection with Nagaon PS case number 1063/2024. Stop. They shall be allowed to go on interim bail by the arresting authority on furnishing a bail of rupees 30,000, on furnishing a bond of rupees 30,000 with one surety of like amount, subject to following conditions 1 and 2. They shall cooperate in the investigation. Let this case be listed again on
26/11.
26.
Can it be few days for that?
Because they will have to, after getting interim, they will record their statement. That will also reveal in this
20 or 25?
No, that is not the order. Order is
lordship. After, if
they will not go,
okay,
being female. If they are arrested,
then they will take it.
then they will be. They need not to surrender before. You have to only cooperate.
Once my instruction is that they were served with notice, they have appeared, and once their statement were also recorded, these two ladies.
Okay, we'll find out.
And injury report will also be essential because my instruction are that a scuffle no doubt took place, but the informant did not sustain any injury.
Indian MR.
Call for the
Medical report.
diary along with the injury report of the victim. 21,
21 or
26,
lordship 21, 26,
21, 11,
21, 11.
Lordship, obliged.
21, 11. 30,000
Okay, it's okay.
May I please be honest?
item number.
3.
For 482 application listed and allegations is under section. Lordship, 112, subsection 2 of 318, 4 and 267, Lordship.
1,
File on place 17, Lordship. Kindly may read
no,
the file. Lordship.
what is 112?
Yes, Lordship. 112 is, Lordship, whoever commit any PT organized crime shall be punished with imprisonment of for a term.
Organized crime, organized crime.
Yes, Lordship.
Lordship.
Organized
Lottery coupons.
for a term which shall not less than 1 year, but which may extend to 7 years, Lordship.
Okay, what is the offense?
Offenses, Lordship, may I read the FIR, Lordship?
Yes.
Page number 17, Lordship. সন্মুখৰ নিবেদন এই যে মই মহোদয় অৱগত কৰো যে 1 নং খাপখাতি অৱস্থিত শ্ৰী শ্ৰী ভীম শংকৰ শিৱ মন্দিৰ উন্নয়নৰ নামৰ তলত উল্লেখ কৰা পদকীয় গণে এখন লটাৰী খেল আয়োজন কৰি বহু কোটি টকাৰ লটাৰী কুপন স্থানীয় ৰাইজৰ লগতে বহু দূৰণিৰ ৰাইজৰ বিক্ৰী কৰি আজি ইংৰাজী 20/10/2024 24 তাৰিখে কোনো ৰাইজৰ উপস্থিতি বিহীনভাৱে খেল পৰিচালনা কৰি এক ভুৱা ফলাফল খাপখাতি অস্থায়ী কাৰ্যালয়ৰ এখন বেনাৰত ওলোমাই দিয়ে। Lordship, in this case, what happened, the FIR Lordship itself reveals that the petitioner organized a lottery game Lordship, and the result was out. As per the mentioned date, earlier mentioned
False
date,
result
Lordship,
was-
2010-2024. The result was out, Lordship, but though the informant, they are not in the lottery game, Lordship, therefore they lost the FIR, Lordship. Lordship, page number 18, Lordship. The informant address, Lordship, they are from the different village, Lordship. And the lottery game was organized on Khapkhati 1 Nong village, Lordship, and
Is-
How 267 is involved? BNS 267.
267.
Yes, there will be required lordship. It's a,
No, election is of cheating and
cheating
Yes,
of,
lordship.
having a lottery game lordship. And the result was false lordship. Result was hang on a banner in a temporary office located in Khapkhati. The result are completely false. The members
means-
have embezzled crores of rupees lordship. So let the CD be there lordship. The
Yes.
public without
Lordship, interim may be granted. Why, Lordship? Because that,
who are you?
Lordship, I am
President.
the president, Lordship, Ramlal Raspur, yes. Lordship, interim may be granted. I will appear before the IO, Lordship, and cooperative, Lordship, because as per the FIR, Lordship,
And who are the other two? Mithu Rajbhar, Joseph Basumatari.
yes, Lord, they are also, they are one of treasurer,
318.
treasurer and assistant secretary, Lordship, for Mithu Rajbhar.
Third Miss, what is your name?
K. Malaka, Lordship.
Third Miss K. Malaka, Learned Counsel for the petitioners. Also heard Ms. A. Begum, Learned Assistant for the prosecutor. This application under section 482 of BNSS 2023 has been filed
318.
by the petitioner Ramlal Rajbhar, Mithu Rajbhar, and Joseph Basumatari, who are apprehending their arrest in connection with whether police has gone for searching you,
Yes, Lordship.
apprehending their arrest in connection with Udalguri PS case number 126/2024 under section 112 within bracket 2/318 within bracket 4/267 of BNS. As the gist of accusation against the present petitioner, in brief, are that on 2010-2024, one Ajal Tati had lodged an FIR before the officer in charge of Udalguri Police Station, Inter, alleging that the 5 numbers of accused persons named in the FIR, including the present petitioners, have organized a lottery game in the name of development of Bhima Shankar Shiva Mandir located in number 1 Sap Khaiti to local people. And it is alleged that they have cheated the purchaser of the lottery by falsely declaring the results on 2010-2024. Stop. It is also alleged that the petitioners have embezzled crores of rupees by announcing the fake result. Stop. Learned counsel for the petitioner has submitted that the allegations leveled in the FIR against the present petitioner are not true. He submits that the results of the lottery was declared duly on 2010 to 2024. Stop. It is also submitted that the petitioners are ready to cooperate in the investigation. Stop. On the other hand, learned additional public prosecutor has submitted that the perusal of the case diary would be necessary. Stop. Call for the case diary.
Lordship on 26th of November.
26, fixing 26/11/2024 for case diary. In the meanwhile, considering the submissions made by learned counsel for the petitioner as discussed herein above, the petitioners who are the president, assistant secretary and treasurer of the committee which conducted the lottery game are directed to appear before the investigating officer of Udalguri PS case number 126/2024 within a period of 10 days from the date of this order and cooperate in the investigation. Stop. If they do so within the stipulated period of time, in the event of their arrest in connection with Udalguri PS case number 126/2024, the above named accused persons, above named petitioners shall be allowed to go on interim bail of rupees 30,000 each with one surety of like amount, subject to following conditions. Number 1 and 2. Let this case be listed again on 26/11.
I am grateful, Lordship.
My last item number 9. I could not go to the scan copy today, and it was dealt by my colleague, my lord. So can it be informed that day, my lord? Wednesday?
Wednesday, madam.
Heard Mr. M. Chaudhary. M. A. Chaudhary, learned counsel for the petitioner. Also heard Mr. R. R. Kaushik, learned additional public prosecutor, who praised for some time to go through the scan copy of the case records which were requisitioned in connection with this case before making his submission in this case. The prayer is allowed. Let this matter be listed again on
Wednesday, madam.
Wednesday is which date?
It's 13th, madam.
13/11/2020.
DPO.
Mannan.
None have.
I'm sorry, Lordship, after time, some time, Lordship, Vice Mannan will take it. After some time, Lordship, he's coming.
I support the time being note.
As usual, Lordship.
NCB is never ready.
Lordship, he is on legs, Lordship, always.
NCB needs more counsel because you have more cases. Okay,
At two, Lordship,
okay, two.
at two.
Made, please, your lordship. The bail application. Yes, the petitioner was arrested on 26/9/2023. In this case, it's a sworn arrest,
26/9,
26/9/2023.
just a minute.
Though the petitioner was not named in the FIR, he was basically arrested on the suspicion and on the statement of the co-accused. I was just giving the points first, I'll come.
Yeah.
And nothing was recovered from the petitioner. There were 14 witnesses, out of which 8 witnesses were examined. Now, in this case, your lordship, I have annexed the witnesses, a statement of the witnesses. In the statement, none of these 8 witnesses has implicated the petition. And even the punch witnesses have specifically did not mention anything. Some are signatures are taken later on, some not even present, they have not seen. These are the witnesses, statements of the witness. Now, your lordship,
How many listed witnesses were there?
the total listed witnesses 14,
And 8 have been.
8 have been examined.
None has implicated.
Not a single one. That's why I have annexed those. And also, I think the scan copy is also already there.
Now, how will you overcome 37 MBR?
That is it. That is why. First, I'll take your lordship to a few judgments of the Honorable Supreme Court as well as this court, just to point out that in such a case where there is hardly any implication by the witnesses, 2 things will come. If it is a punch witness, 2 things will come. Hardly any implication. Secondly, if these witnesses were not signed in the normal manner, the I think seizure witnesses have not signed at the point of time, not seen, or the total amount which has been recovered has not seen, then even 52A will be violated. That also will come, but I'll just say that at this moment of time, when there is hardly any implication, this court should not entitled to bail. That first judgment I will rely on is Muhammad Muslim. The judgment most lordship has most of the time have seen that, but here in this case, I'll rely on that judgment. I'll come one by one. There are few judgments.
My lord, since my learned friend is relying some judgment, I would like to reply on that, my lord. Let him finish today, my lord. I will give reply in another day.
No, don't take back step at the initially. You
No, because my lord, I have not got the scan copy also, and since my learned friend is taking law point, so I have to reply that.
No, it's
Let-
better if your lordship, it's done at the one point of time. Otherwise, I'll make a submission again on the,
yeah, it is difficult for me also.
yes, even also because
on the next day also,
Because I
We
have
have-
to bring my case close also.
you give a list of judgment to him so that
I'll give it to him. your lord.
he,
I'll give it to
he
him.
can be prepared.
Yes, I'll give the judgments to him. Lordship may fix it day after tomorrow or Thursday.
Day after tomorrow, lot of cases.
Goodbye, head process.
You-
Thursday, your lordship.
Thursday date.
বুধবারে মোৰ এটা তাৰমানে হেৰি
What is your case? What is your case?
This
That it is not recovered from your possession.
number 1. In this case, I am shown
Sorry.
arrested.
You are implicated only on the basis of
The
It-
statement of a
co-
co-accused.
any other material.
No, I have nothing was recovered from me. There was nothing against me in the evidences, 8 witnesses, nothing against me. your
No,
lord.
but during investigation, what
Investigation that only statement of co-accused have gone against.
apart from that,
Nothing else, your lordship. Oh, there was only a transaction of some money was there
between you and
and one of the co-accused.
co-accused. And is there anything to show that that money relates to,
No, that nothing has been.
how have you explained?
That was that amount. Yes, that was, we have stated that there was the children, because both the child are having some specific illnesses which required huge amount of
money for treatment. He has been treating it outside. So there was some money taken from him, or he has taken some money. On the basis of that, some amount has transaction was there. This is what we have
Yes,
stated.
my lord, as far as traffic, my lord, he was present at the place of occurrence and ran away. My lord.
No, no, that there was that evidence. That is why I'm saying what they have stated, that he was present in the place. There were two cars. He said that he was in another car and he ran away in that car. But the CCTV of that particular toll gate does not show that. This is also recorded, and the person in the toll gate is also a witness. He has not stated anything. This is why I'm saying
These are
they
matter
have
of
just
trial, my
stated
lord.
that.
These are
But-
matter of trial, my lord.
That is why.
Oh, but-
Let him go through it.
Okay, we'll take it up day after tomorrow. When
Wednesday,
Thursday,
some
Thursday,
difficulty,
when?
Thursday.
Thursday, my lord.
Thursday. But you have to also persuade this court that in a bail application in midst of trial, these things can be considered. While
Yes. That,
you have-
that judgment, your lordship, kindly, I'll just point at the Muslim judgment that states that. I'll take back that copy today. I'll give it on the next day.
That's
Our-
the flow of the-
Mr. Y. S.
Did I-
Manan, Learned Counsel for the petitioner. Also heard Mr. R. R. Kaushik, Learned Additional for the prosecutor,
Martu judgment ki hai, like,
who
that is an-
is first time for preparing the case,
Pretty number.
for going through the scanned copy of the
14 number.
record.
Oh,
and
14 number.
The prayer is allowed. Let this matter be listed again on
Thursday,
Arts
my lord.
DL.
14 এটা একটু ঘোরাই দিও
একটু লই লবা, copy. This is the lordship. And in this case, on 29, 2024, lordship was pleased to call for a report on the trial court matter. We ascertain whether examination of witness took place or not.
That report is there, my lord,
That report is there, my lord.
and no examination took place.
And my lord,
No, nobody,
Yes, my lord.
no, not even a single witness.
no, my
No,
lord.
my lord.
And my lord, from the report, it is found that it is now fixed for 28/1/2025, my lord.
What is the offense?
My lord, it's a recovery of commercial quantity of heroin from a vehicle which is loaded with 700 scrap materials, my lord.
How much heroin was recovered?
739.01 grams.
0.01 grams.
And who are you?
But I was traveling in the vehicle along with two other persons, my lord. One Abul Hasim Hussein and
Oh, yeah,
one Abul Hasib and another one Sharif Jubair Ahmed.
And what is your case?
My lord, I was traveling in, I'm my lord, I sell my lord plastic and other utensils, my lord, when running, going to my lord daily markets. On that day, I was coming from my lord Hathagandhi and loaded my small my lord portly of goods, my lord, and traveled in this vehicle, my lord. And in midway, this vehicle was stopped, my lord. It was searched. It was not searched, my lord. It was then taken to police station, my lord. That scrap materials were then unloaded, my lord, and these contrabands were found, my lord. It was hidden inside the scrap materials, 700 kgs, my lord.
He was
And
at
this
the vehicle.
belongs to you.
No, my lord. That scrap, I noted, my lord, belongs to him. It can be well answered by the
What is your explanation why you were in the vehicle? How and why? Bolero pickup truck.
that for explanation is not there, but paragraph 2, my lord, I have stated that I sell my articles, my lord, going to the market to market, my lord. And in this way, my lord,
Your plea is prolonged incarceration.
yes, my lord, that is another plea, my lord. Earlier, it was rejected by your lordship.
Where is the?
Yes, it is, my lord, annexed at page 29, my lord. That was argued on merit, my lord.
It's page 29, my lord. And there, my lord, violation of section 52 was argued, my lord. Paragraph 6 is
Yes, Mr.
But so far on merit, Lordship has already dealt in the earlier rejection order.
But prolong incarceration.
Only point is follow incarceration. My lord,
And
here,
when the charges were framed,
it's 37 2024, my lord.
yes, sir.
Have the certified copy, my lord.
and how many accused persons are there?
3 accused persons are there, my lord, and one is absconding, my lord. That owner, my lord.
Madam, here some delay took place because my lord, one of the person is absconding. And subsequently, this matter was split up. And that order was passed on 34/24.
30?
4/24.
But 030 rejection, my lord, 030.
No, no. Follow photos, skip কৰি দিবলৈ। এটা absconding হ'ল।
Very good. Mm, 693 days. 1 year, 10 months, 23 days.
You have any judgment in your favor?
My lord, I have prepared a small compilation for the lordships. There is a lordship. The my lord, where prolonged
My
incarceration.
submission would be, my lord, because those cases where the follow incarceration was discussed, those facts are different. Here also the facts are different. And those cases, not only follow incarceration, the court also observed that there is no possibility of completing the trial. And that issue we cannot say in this case right now. Because here delay took place because one person was absconding, my lord. So the SARS could not
No, but
file,
here
my lord.
also, even after
1 year, 10 months. perhaps.
Yes, my lord, I am in custody for 1 year, 10 months, 23 days as on today, my lord, which stands at 693 days, my lord.
Because my lord, Honorable Supreme Court has not fixed any particular period of time that this is the
Yes.
incarceration. So
but
just
I think
my lord.
there is a prolonged incarceration. Even a single witness has not been accepted.
Yes, that is true, my lord.
So the possible, and next date is fixed in January.
January.
Sorry.
My lord, because
Right.
why single witness could not be examined? Because initially one person, the main accused, one of the owner of the vehicle was absconding till now, my lord. Then subsequently this case was split up.
My lord, split up charges were framed on 37/24, my lord, then
And how this accused was implicated?
He was
Because
in
he
the
was
vehicle.
found in the vehicle.
He has a vehicle. Because my lord, here the conscious possession will come, and because in case of a private vehicle, the parameters of conscious possession is more strict than the public vehicle.
that is a Bolero pickup, my lord,
Pickup vehicle.
pickup vehicle.
That's not,
But
Yes.
this is not a passenger vehicle,
that is not a
It's for
passenger
a
vehicle.
passenger vehicle, but it's carrying
It's a
for goods,
private
my lord.
vehicle.
goods carrying vehicle.
Goods carrying. And it was carrying goods, my lord, 700 kgs of scrap materials was there.
But that is not a
And
passenger carrying vehicle.
why you took lift or you,
But I took lift because I also have my my lord, my material plastic utensils, my lord.
heard Mr. M.A. Chaudhary, Current Counsel for the petition. Also, Mr. R. Kaushik. an additional public prosecutor. His application under section 483 of PNSS has been filed by the petitioner, namely Jamir Din, who has been detained behind the bars
My lord, it's
since 19/12/2022 within bracket for more than 1 year, 10 months in connection with special NDPS case number 117/2020, which is pending in the court of learned Session Judge Karim Stuff. The gist of accusation in this case is that Court para 3 from page 29. Stop. Learned counsel for the petitioner has submitted that before filing the instant bail application, the petitioner had approached this court on an earlier occasion also by filing bail application number 3956/2023, wherein he took the plea that the mandatory provision of section 52A has not been complied with in this case. However, the plea was rejected. On the earlier occasion, the petitioner also took the plea of prolonged incarceration, praying for bail. At that point of time, he was detained behind the bars for 471 days. The prayer for bail was rejected at that point of time, as the period of 471 days was not considered to be long enough to give the benefit of bail on the ground of prolonged incarceration to the present petition. Stopped. Learned counsel for the petitioner has submitted that after rejection of the aforesaid bail application, 6 months have lapsed. However, till date, out of 8 listed prosecution witnesses, even a single prosecution witness has not yet been examined by the prosecution side. Learned counsel for the petitioner has also submitted that the petitioner boarded the vehicle. The petitioner is a small
businessmen are dealing in plastic materials.
is a petty businessman dealing in plastic and steel materials and used to sell the items, plastic items from market to market. Stop. It is submitted by learned counsel for the petitioner that on 2022, the petitioner boarded one Bolero pickup van. That is the vehicle from which the contraband was later on seized, along with his materials. And he was not aware that the contraband which was recovered from the vehicle was being carried in the said vehicle. Stop. learned counsel for the petitioner has submitted that though the quantity of contraband seized in this case is of commercial quantity. However, as the petitioner has been detained behind the bars for more than 1 year, 10 months, and not even a single witness has been examined till date, the prospects of early culmination of trial is very bleak. He also submits that under such circumstances, the petitioner is entitled to get bail on the ground of prolonged incarceration only, as his fundamental right guaranteed under Article 21 of the Constitution of India overrides the embargo of Section 37 of the NDPS Act. Fourth para 8 form from bail application 3881 /6. Fourth para 8, fourth para 9. On the other hand, learned additional public prosecutor has vehemently opposed the grant of bail to the present petitioner on the ground that the petitioner was found in the vehicle which the contraband was seized, and the said vehicle was the private vehicle, and therefore he was found in conscious possession of the recovered contraband. Learned additional public prosecutor also submits that as the quantity of contraband seized in this case is of commercial quantity, the embargo of Section 37 of the NDPS Act is applicable to this case. So he also submits that the benefit of prolonged incarceration may not be granted. No, the benefit of bail on the ground of prolonged incarceration may not be granted to the petitioner, as the charges were framed in this case only on 30/7/2024, and there are only 8 witnesses who can be examined immediately.
And my
And
delay occurred because one of the accused is absent.
he also submits that the delay in proceeding with the trial occurred not due to any fault on the side of the prosecution, but because one of the co-accused was absconding, and the case of the present petitioner have to be split up from the case of the absconding accused, and same was done on 3rd of April 2020.
30th.
30 April 2020. I have considered submission made by learned counsel for both the sides and have perused the materials available on the court, including the scanned copy of the NDPS case number. What is the case? 170/2022, which was the requisition from the trial court. Court para 17 from 3881/18. 19. year, 10 months. And even a single witness has not yet been examined. It also appears from record that the next date before the trial court is fixed on
28/01/25.
28/01/2025. Under such circumstances, it is unlikely that the trial would culminate at the earliest. And this court is of considered opinion that the incarceration undergone by the present petitioner in the present case would be regarded as long enough to override the embargo of section 37 of NDPS Act. Therefore, this court is of considered opinion that the petition is entitled to get paid the ground of prolonged court para 50,000 with 2 security.
My lord. 2 sureties, my lord.
2 security of like a certain fund.
Deeply object.
No, 1 lakh.
One.
1 lakh with 2 security.
Per person, my lord.
No,
For this 2 sureties, my lord, local sureties.
your story may not be true also.
I will, my lord, definitely.
I'll take a short break of
Right.
1.
Previous lordship's audience, my lord. Item number 6, my lord. Can I pray that the matter will be taken up at 2 p.m., my lord?
My lord, here I am on the other side. I have not received the, any extra copy is required, my lord. So if you can serve us, my lord, it can come after 2 weeks, my lord. Because I have not gone through the.
Let us hear them
Yes, sir.
at 2.
Yes, please.
So it
Who is the counsel?
are there, I don't know.
Call after, sir.
He not it
None has appeared for
was here.
Ebora.
It was here.
Okay. We will call it after. sir.
After.
It is the lordship. In this case, scan copy and present status was called for.
That was not the
376, 366, and he is behind the bars since 125 days today.
scan copy and status doesn't,
Lordship,
has not received.
kindly, if your lordship kindly,
Scan copy has arrived? No.
in this case, the FIR was lost. Allegation is against father, brother, and the present petitioner lordship. Later on, father and brother was final report given and charge sheet was filed against the petitioner in lordship under section 366 and 376. Your lordship kindly see annexure 3 medical report.
But sincere.
It was
sincere
already
should be-
called lordship, so kindly a short date.
What is your case?
His lordship kindly see FIR. That is page 8, lord. Relevant portion, page 10. I have the honor to report before you that my daughter, namely Sajida Begum, 19 years, standard of 9th class in Jerry
No, okay. So an allegation of rape is there.
against lordship petitioner, his younger brother, his father. Later on, charge sheet was submitted, lordship. Annexure 2, page 11. There is a land dispute, lordship. In respect to that, the case arises, lordship. page 11, annexure 2.
No, now witness charge has been framed.
Yes, Lordship, 366, now
Charge has been
converted,
framed.
no, Lordship. Trial not yet started, Lordship.
At least,
Jabir Hussain and
at
Abdul,
least victim has to be examined.
Lordship, 19 years and 376, Lordship.
The
No.
accused is 19 years
No,
old.
Lordship, victim is 19 years. It's not a POCSO case.
No, but still it is a 376 case.
Lordship, kindly see annexure 3,
Okay.
page 15, Lordship.
No, what is your case? What is your stand?
My stand
That
is
it
that,
is a false
Lordship,
case.
yes, Lordship, this is a false case, Lordship. Rape against father and brother and the petitioner, whether it is believable, Lordship.
Yes,
And he
that
has
may not be
undergone an Lordship, operation page 15, annexure 3. Major operation was done on the petitioner, Lordship, in the year 2022 December, Lordship, in the Bangalore, Lordship. And thereafter, only one checkup was done and the next checkup is yet to be done. So if your Lordship kindly consider, I'll cooperate with the Lordship.
No, let us
Proceed.
peruse the,
Then Lordship short date mechanism.
which court
Karimganj, Lordship, that is
heard Miss R. Chaudhary, learned counsel for the
Badarichera PS, Lordship.
petitioner. Also heard Mr. R. R. Kaushik, learned additional public prosecutor. On perusal of office note dated 8/11/2024, it appears that the scanned copy of the trial court record which was called for along with the status report of the trial has not yet been received by the registry staff. Let a reminder be issued for the same. Registry to take steps for this. Let this, when can we fix it?
Already noticed earlier there is a call for LCR. So another date, Lordship, after 1 week if possible. Lordship. Okay.
Yeah.
25th,
Monday,
25th or 26th.
25th, Lordship.
Let this case be listed again on 26th, 5th of November.
Obliged.
Please, your lordship. SDRE was called for, my lord. I'm under behind bar for many days.
Is
my
there
lord.
is there?
He did not receive, my lord.
It can be on 13, my lord. This is by Hata on the Ronia district, my lord.
What is the offense?
This fake currency, my lord.
And how many days you are behind the bar?
My lord.
Mr. Kaushik, you suggested it.
My lord, can be on
Thursday.
13.
13.
13, my lord.
Okay. Heard Mr. D. Bora, learned counsel for the petition. Also heard Mr. R. R. Kaushik, who
They are not-
submits that the case that he has not arrived and prays for some more time for producing the case that where is the law? Let this matter be listed again on 13th of November 2024.
Deeply obliged, my lord.
Sorry, my lord, I was in court number 18, lord. And in this case, lordship, the petitioner,
Yes,
and petitioner is a doctor, lordship, and he conducted discharging his duty, lordship. And lordship, and subsequently one patient died, lordship. And as on today, lordship, 72 days in custody. Lordship.
oh,
And the section is, lordship,
investigation is going on.
But an investigation going on, but the last entry is,
Now, what is the offense?
my lord, termination of pregnancy, my lord.
Oh,
so I am the doctor, lordship, and senior doctor, medical officer, lordship, and I am providing document.
Last update is 5/9. And my lord, he is a Ayurvedic doctor, a government doctor, and conducted the, my lord, this abortion in his residence, my lord, in the quarter.
in residence.
Quarter within the campus, lordship. And I am mentioned in my petition, para number 4, lordship, and may coming to the lordship and page number 19, lordship. page number 19.
Yes.
May I read, Lordship? And very clear, Lordship.
What is this, page 19?
19 is Lordship, the deceased Lordship is a lady and a woman, Lordship. And
No, what is 19? Page 19,
online.
yes.
Lordship, that is the inquiry report of the inter case is here, Lordship.
So before lodging of FIR, an inquiry was conducted.
Yes.
Lordship.
Okay,
So, my lord, may I read, Lordship?
yes.
With reference to the subject cited above and letter under reference, the undersigned is inquired into the case and observation thereof are laid down for your kind perusal and further action. The undersigned have visited the house of the deceased Basaton Nessa, wife of Rafiqul Islam, on 31st July 2024. During the visit, we found the deceased Basaton Nessa, wife of Rafiqul Islam, already had 2 children, and she denied to being pregnant when they concerned Asha and Sofiara Khatun and visited her as per her routine activity. But on 15 July 2024, she asked her husband to take her to the by the SHC, that is medical lordship, for health checkup. As per the hospital admission register record and the registration number so and so, during the checkup, the disease was confirmed by hospital that she was pregnant. On 31st so and so, during the Rafiqul Islam husband Basaton Nasa was absent and his father has Harezuddin and other Asha from Satabari AMM, namely Hafiza Khatun, informed us that Basaton Nasa attended by the SHC under Lokipur CHC with her husband for MTP on so and so. As informed by the witnessing Asha Hafiza Khatun, MTP was conducted in residence of the doctor concerned, and namely Dr. Mahmoud Hussain,
And has cooperated in the investigation. Stop. Learned additional public prosecutor has produced the case diary and has submitted that the petitioner has appeared before the investigating officer and his statement under section 183 has also been recorded.
180, no. No, 180 hobo. 180.
180 of BNSS has also been recorded. Verify,
And very,
because if something goes
should be
wrong,
180, ma'am.
180,
180, ma'am. Yeah.
161 is equal to 180. 180. 183 is 164.
183, 154.
180 of BNSS.
180.
Stop. Considering the fact that the petitioner has complied with the direction of this court and has cooperated in the investigation, the interim anticipatory bail granted to him by order dated 3/10/2024 is hereby made absolute, with the conditions attached to the said order remaining intact. The above anticipatory bail is accordingly disposed.
Deeply. Noted 21 and 24 taken up together. 24,
21 and
21 and 24
24.
taken up together, madam. Same case, madam. They both the accused petitioner appear before the other, and their statement was recorded.
Who is for 24? You are for
Yes, sir. It's for the last direction, Lordship, I appeared before the IO, Lordship. And statement is also recorded.
your name is K. Malaka.
Yes, Lordship.
Heard Ms. K. Malaka, learned
Petition with a-
counsel for the petition. 21 and 24. Separate. Also heard Mr. M. Fukon, learned public prosecutor Assam. Learned counsel for the petitioner has submitted that the petitioner was granted interim anticipatory bail on 3/10/2024 by this court and in pursuant to the directions of this court, the petitioner has appeared before the investigating officer and has cooperated in the investigation. So, Mr. M. Pukon Leonard, Public Prosecutor Assam, has produced the case diary of CM Vigilance PS case number 4/2024 and has submitted that the petitioner has appeared before the investigating officer and his statement under section 180 of BNSS has been recorded. Stop. Considering the fact that the petitioner has complied with the directions of this court and has cooperated in the investigation, the interim anticipatory bail granted to the petitioner by order dated 3/10/2024 is thereby made absolute, with condition number 1 and 2 attached to the state order remaining intact. The aforesaid, the anticipatory bail application is accordingly disposed of. 21/24 same order.
Much of it.
I am grateful, Lordship. 24 item, Lordship, it was on, interim order was passed in 1510,
24
15th.
date of interim order is
1510 next.
15/10.
Yes,
In 21 it is 13/10.
yes.
24 15.
310, Lordship, 21 is Lordship, passed on 310.
310 or 30 or 310. In 21, the interim order dated is 310. In 24, it is 15/10.
Yes, Lordship.
Other things will remain same.
Smile.
I am grateful,
of it.
Lordship.
Item 22 CP which PM was called for, did he receive without the postmortem report? We need the postmortem report here.
What is the case?
The murder.
Murder. What is your case?
Lordship, I'm the friend of the accused, and I was just jogging in the park where I have seen that the elder son of the deceased, as the friend, I have seen him carrying his father, and I was nowhere related in this case. I just seen him, and later on I got to know about the death he is died by heart attack. I am nowhere related, but the complainant has taken my name in the FIR. FIR is in page number. I copied in page number 7.
Read the affair.
With due respect, I would like to inform you that myself, Srimati Janmoni Borua, is the second wife of Sri Jalandhar Kurmi. Since the last few years, due to constant physical torture in the hand of my husband's son, my husband had rented a separate accommodation for me at Sanmari, Golaghat. My husband came to Jamuna Park, situated at Golaghat, on 29 2024 to give me the monthly house rent and expenses for the food. Out of nowhere, his elder son and Sri Bitumon Kurmi and nephew Sri Janto Kurmi came and started kicking.
What is your name?
My name is Janto Kurmi.
You are friend of Bitupon.
Yes. But the postmortem report is essential.
Essentially.
Because there are two versions, my lord, here. That lady,
She says that
he
were
was
assaulted.
beaten up, and his son is one of the accused. But his statement is that, my lord, that his petitioner saw his father sitting with two ladies in the park, my lord. Subsequently, he was called by his friend, and when he came, he put his father in his car, and he subsequently died in the car because he was having difficulty in breathing.
There was no assault.
There was no, as far as son, he is one of the accused also.
Then postmortem report would be required.
Also, if interim may allow, because I'm nowhere
Because
related.
there are two ladies, they said that these two petitioners beaten up the.
Now, what is the statement of Janmoni Burwa regarding
My lord, the plea said that my lord, this petitioner along with his son beaten up the
petitioner also beat up. Or then postmortem report. Heard Mr. What is your name?
Amen.
J. Mena, Learned Counsel for the petition. Also heard Mr. R. Kochek, additional who submits that though there was a direction for requisitioning the case diary along with postmortem examination report. However, the case diary is available, but without postmortem examination report. And prays for some more time to. How much time?
But I think I'll have to send back the CD.
Okay. For postmortem examination. The prayer is allowed. Let the case diary be sent back to be recalled again along with the postmortem examination report. Let this case be listed again on
My lord, 27.
27.
Okay.
I plead to lordship. Lordship, I have already appeared before the concern.
You were on interim bail.
Yes, your lordship. Interim date is 21/10/2024, lordship.
CD not received.
What is, you are on interim. We can extend the interim for one more day. Heard Mr. R. Chetri, Learned Counsel for the petitioner, who submits that the petitioner was granted interim anticipatory bail on 21/10/2024, and thereafter he appeared before the investigating officer and has cooperated in the investigation. So, on the other hand, an additional public prosecutor has prayed for some more time for producing the case diary. The prayer is allowed. Let this case be listed again.
My lord, on 26 November.
26 November, the interim order of the interim bail shall continue till next day.
Much obliged.
25 CD not received, my lord. He's on interim.
Heard Mr. What's your name?
A Deka.
Heard Mr. A. Dekar, Counsel for Learned. Also heard Mr. R. Kaushik, Learned, additional public prosecutor, who prays for some more time for producing the case diary. The prayer is allowed. Let this case be listed again on 27.
Interim maybe.
27 November. The interim order shall continue till next day.
No pleasure. So this is an anticipated value of application, lordship. Lordship will find the affair at page 11. Mr. Vernick 11. May I read it, lordship?
Yeah.
সম্মানপূর্বক বিনয় নিবেদন এই যে আজি ইংরেজি 6/9/2024 তাৰিখে নিশা প্ৰায় 7:30 বজাত অধীনৰ ঘৰত অনাধিকাৰ প্ৰৱেশ কৰি হাতত থকা অস্ত্ৰ লৈ ঘৰত ঘেৰাবৰ্ষণ কৰি অধীনক আৰু মোৰ জ্যেষ্ঠ পুত্ৰ দীনেশ দলে প্ৰাণী মৰাৰ ভাবুকি দিয়ে। সেই সময়ত অধীনৰ বোৱাৰীয়ে কথাবোৰ জানিব বিচৰাত দুৰ্বৃত্ত দলে বোৱাৰীৰ বুকুত ধৰি টনাজোৰা কৰাৰ লগতে হত্যা আৰু ধৰ্ষণৰ চেষ্টা কৰে। That is the allegation, Lord. Actually, the petitioner won along
It
with
is there.
It is here, my
What is the
But CD, these family members of the complainant, they have stated that my lord, these prisoners came and assaulted them and tried to misbehave with the sister-in-law. And one independent witness is also there, my lord. He is the neighbor of the complainant. He also stated the same, except that sister-in-law.
misbehavior.
So anybody is injured?
No.
Nobody. Any property damage?
No.
And no molestation.
No molestation, but they have taken
But
the plea, my lord.
what the daughter-in-law herself
Sorry, the child law, my lord. My lord, she is only saying অশালীন গালি দিয়াৰ উপৰিও মোৰ শালীনতা ভংগ কৰিবলৈ দেৱত মেটকে মই পৰিধান কৰা চাদৰৰ আঁচলত হাত মাৰি ধৰে। লগে লগে তেখেতে নিজৰ শালীনতা ৰক্ষা কৰি ঘৰৰ ভিতৰলৈ প্ৰৱেশ কৰে।
who
ভৱেশ মেটক।
who is the petitioner?
Petition number 1.
Huh?
Petition number 1. Bhavesh Mehta.
Then what is your submission?
Custodial case. Right. Because these dependent witness only, they are saying they use slang language.
BC Group.
Third, Mr. P.K. Gogoi, counsel for the petitioner. Also, Mr. R. Kaushik, petitioner public prosecutor. His application under section 482 of PNSS has been filed by the petitioners, namely 1, 2, 3, and 4, who are 4 and 5, who are apprehending their arrests in connection with Jonai PS case number 95 under section 329 the bracket 4 slash 125 DNS. The gist of accusation in this case is that on 7/9/2024, one Gangadhar Dole lodged an FIR for the officer in charge of Kanai police station, inter alia alleging that the petitioners who are named in the FIR as accused person trespassed into the house of the informant armed with sharp weapon and started pelting stones and threatened the informant of killing his elder son. It is also alleged that petitioners tried to outrage the modesty of daughter-in-law of the informant and also tried to kill and rape her. So, what is your submission?
Actually, from the upper itself, it is an exonerated expert in presence of her husband.
But you went there.
Lordship, actually, what happened on that alleged lordship, there was a bike rally organized by the Jono Jagaran political party. And two persons, lordship, one is lordship Pranab Pegu and another one is Uttam Medok. They were escorted by the son of the informant. And I am Bhavesh Medok is the relative of the informant.
So there was some altercation.
There was some
When counsel for the petitioner has
That is outside the house of the premises of the
submitted that on the date of incident, that is on 6/9/2024, there was some altercation between the petitioners and the first
Nothing.
informant regarding assault of a person in a bike rally which was conducted on that day. Stop. However, he submits that the allegation of rape and threatening made in the FIR is exaggerated and false. Stop. Then an additional public prosecutor has produced the case that of the Dhemaji PS case number,
Jonai PS,
Donai PS case number
92 of 2024.
92 of 2024 and has submitted that though the family members of the informant have implicated the present petitioner, however, implicated the petitioner number 1. However, there is no material of attempt of rape in the affair. He also submits that the statement of independent witness recorded in the affair during the investigation also does not indicate the allegation regarding molestation. So, considering the submissions made by the counsel for the petitioner as well as additional this court is of considered opinion that if the petitioners cooperate with the investigating officer, their custodial detention may not be necessary for fair completion of investigation of the NDPS case. That stuff. And this anticipatory bail application is disposed of with a direction to all the above named petitioners to appear before the investigating officer of NDPS case number 22/2024 within a period of 10 days from the date of this order and cooperate in stuff if they do so within the stipulated period of time. In the event of their arrest in connection with NDPS case number 19/2024. Stop, the above named petitioner shall be allowed to go on bail of rupees 30,000 with 1 security of like 1 security of like amount each. 30,000 each with 1 security of like amount with following condition. Number 1, with above of the with bail application. Hereby disposed of.
If you have like.
Yeah.
With small player with the with regard to item number 9, it is a part-heard matter and Lordship has fixed on 13th. I fail to intimate Lordship at the motion at the hearing stage matter. So keep it as part-heard matter. Item number 9.
Item number 9, we have we heard? We have heard.
Madam, it was fixed by your Lordship on 13th of November. Madam. Next.
I took time.
Okay. So it has to be kept as
Part-heard matter.
9 to item number
9, madam.
9 part-heard.
I'm deeply aware.
Because another matter was there.
Notice was not.
No, notice was not. That instruction I had. So we had, and the office notes also reflect that, my lord.
So what is your prayer?
My prayer is, my lord, since
Not received the
yes,
copy
yes,
of
no copy.
I'll give him a copy of that. That is not a matter thing to be told to the court.
I
My
am
he spoke to
absolutely
me in the
unaware
morning.
of the matter, my lord.
He spoke to me in the morning. I had told him that I'll give him a copy, my lord. That is not the issue. But then the matter has come up for admission, my lord. And my lord, admission, as your lordship knows, my lord, admission is always a matter between the court and the petitioner, my lord. And my lord, kindly see the facts of this case, my lord. I have come up for quashing of a criminal proceeding, my lord, before this honorable court.
On what ground?
My lord, on the ground that, my lord, the entire allegation which has been made against me is fake, my lord. And my lord, the fact that, my lord, there are a number of cases which has been filed, my lord, against me. And my lord, all those were filed after the lodging of this FIR, my lord. And in this FIR, a statement has been made saying that, my lord, that I am a, my lord, habitual offender and all these sort of things, my lord. And my lord, the basic, my lord, ingredients in this FIR, the allegation against me is that, my lord, that I had agreed to, my lord, sell, my lord, lease out a plot of land, my lord. And that thereafter, I have accepted some money as advance, my lord, and thereafter, after I was not
So
confident.
cheating has been alleged.
Yes.
Cheating has been alleged, my lord. Now, whether, my lord, for the purpose of, my lord, now going into this aspect, my lord, on investigation, because, my lord, if your lordship sees, my lord, there is an order at page 26, my lord.
Now what has happened? the
My lord,
charge sheet has been held.
Ultimately, yes, my
Yes,
lord.
charge
Charge sheet has been filed, my lord.
that we have come to know from the reports, my lord. My lord,
Sheet has been filed.
Charge sheet
Right.
has been filed and I have challenged the entire proceeding, my lord.
No, then on what ground you are,
The ground is that my lord, there was no investigation and the charge sheet which has been filed against me is also fraudulent, my lord. Because if your lordship kindly sees the FIR which has been filed against me, my lord, the basic allegation which has been made is that I had entered into an agreement and I was incapable of performing that agreement, my lord, which has been, and that I had reflected myself to be an owner of some amount of land, my lord. And my lord, now for the purpose of investigation of that Chanmari PS case, my lord, what was first required to be proved was whether, my lord, I was really in possession and I had the authority to enter into that agreement or not, my lord. Now that has not been, my lord, stated anywhere, my lord. And if your lordship kindly comes, my lord, lordship kindly sees, my lord, page 26, my lord. Page 26 is an order of my lord bail,
no,
Ji-
but if the charge sheet has been laid,
my lord.
you contest the case before.
No, I will contest the case, but my lord, before contesting the case, my lord, I want to show, my lord, the series of
What is your
allegations,
ground that without any material charge sheet has been laid?
my lord.
You must have a case for
My lord.
quashing. What
Yes,
is
my
the,
The case is that, my lord, the case which I intend to, my lord,
something has been, some offense has been alleged that you have cheated.
alleged, my lord, yes.
Now, whether ingredients of cheating is there or not,
Ingredients of cheating is not there. That is one of the allegation is there. But before going to that aspect of the matter, I want to show before this honorable court the series of, my lord, allegations that has been made against me, along with the series of orders that has been passed in all those cases, my lord.
in other cases.
Yes, my lord. It is all connected,
No, but whether in this case,
my lord,
the FIR which was lodged
my lord.
discloses an offense, whether investigation, because now the stage is has
Yes, my lord.
advanced stage.
Yes, my lord. Yes,
The investigation was conducted and charge sheet was laid.
my lord.
Now, charge sheet has been laid itself shows that some materials are there.
That is what I want.
Otherwise, you can go for discharging in.
My lord, the problem before me is that, my lord, they only want to arrest me, my lord. That is what I wanted to show from the series of orders that has been passed.
No,
This court
for
as well as
arrest,
some others,
you have other remedies available.
my lord.
Remedies against arrest.
My lord, that is there. But even then, when I have already, my lord, contested this, my lord, proceedings, and it has been, my lord, taken up for, my lord, adjudication by this court, my lord. That
No, no.
want to show, my
What
lord.
is the ground for
My lord,
quashing?
my lord.
Then let us issue notice and call for the record, scan copy of the record.
Yes, my lord. Yes, my lord. And my prayer at this stage is to, my lord, stay the further proceedings in that, my lord. Case.
No stay.
Well, ultimately, if there is no stay, my lord, tomorrow a summons will be issued, my lord, if I do not appear out of that apprehension that I may be taken into custody, my lord.
No, why don't you appear? You appear.
No, I will appear if I appear, because that is what I wanted to show, my lord. My apprehensions in appearing, my lord, because in a series of cases, my lord, when I was in custody in connection with this case, my lord, I was shown arrested in a number of cases where, my lord, I had appeared, I have applied for bail, my lord. And when those cases were taken up for consideration by this court and the series were seen by this court, there were direct reflections in the city that there was nothing material against me in the entire city. But even then, my lord, I was shown arrested. So, my lord, the entire, my lord, focus was somehow to get me arrested because there is a title suit pending, my lord, as regards that particular plot of land, my lord, between the owners. And the power of attorney under which I am operating.
No. Remedy against arrest is different. You have that remedy elsewhere.
No, I have
Here
this.
you are challenging that.
My lord, kindly consider, my lord, one aspect of the matter, my lord. Remedy against arrest is there, my lord. It is on two folds, my lord. One is, my lord, that if there is an FIR against me anywhere, my lord, I'll appear for, my lord, or I'll approach this honorable court for a grant of pre-arrest bail. Or, my lord, I'll be taken into custody and thereafter I will again have to appear before this honorable court and approach this court for the grant of bail in that, my lord. That is why I wanted to show why I apprehend, my lord. Why this entire, my lord, thing is, my lord, going on against me, just for the purpose of pressurizing, my lord, me.
When the FIR was lodged?
My lord, this FIR was lodged on, my lord. I'll take your lordship. It was lodged on 19/3/2021, my lord.
So it is a very old affair.
It's a very old affair, my
You
lord.
are not yet arrested.
I was arrested in that case.
and you are granted
I
bail.
was granted bail, my lord.
Then
My lord, there
you
was,
are on bail in this case.
my lord, in this case, I am on bail. But the fact is that, my lord, when I was out on bail, immediately when I was released from, my lord, from the jail, there was a case, my lord,
Other case,
in other cases, my
other
arrested
cases
and
are
again.
not before us.
My lord, I have given a reflection of those cases also.
No, but those cases are not,
No,
we cannot consider merit or demerit of those cases.
I am not praying for the consideration of any merit or demerit in those cases, my lord. I just want to show my lord, I am just placing those records of those cases to show that, my lord, how, my lord, a net has been spread out, my lord, by which I am sought to be illegally taken into custody, kept in custody, so that the title
No,
which is
in this
sitting
case,
somewhere, my
question
lord,
of custody is not there.
my lord.
You are already on bail.
Yes, my lord.
So that fear is not there.
That fear is not there, but the moment I appear for the trial here and seek bail from this court, my lord, then there will be some, my lord, petition somewhere
Other case.
showing some shown arrest in some case, my lord.
No, if some other cases is there,
My
then
lord.
you have to seek.
No, it is not there in my name. Because in shown arrest, your lordship knows, my lord, there
No, now
yes,
that
in my name,
issue notice
my lord.
and call.
Notices has been issued, my lord. Because notices has been issued earlier, that is how he received the copy of the petition along with the summons.
No.
And that is how he has appeared.
Not. We
Notice
voluntarily,
is one,
we voluntarily appeared because there was a bail petition which we were that point of time opposing. So
notice is
issue হৈছে কিন্তু মই এতিয়া সুধিলো পোৱা নাই আমি voluntarily তাত ৰিফ্লেকশ্যনটো আছে নতুন একে নটিচ ইছ্যু হৈছে আমি কপিটো পোৱা নাই
And this is a very old pending.
Yes, my lord.
At this stage, no interim.
My lord, if the interim is not considered, ultimately it is the liberty of a person, my lord.
No interim, some urgency has to be there.
Urgency is the liberty of the person. What can be a greater urgency than that, my
This
lord?
is-
I apprehend, my lord, my liberty.
Since last 2 years.
My lord?
Last 2 years.
Yes, my lord.
When no urgency has occurred for last 2 years.
No, my lord. Recently, summons was issued by this honorable court, my lord, of the CJM, perhaps, huh? By the court of the CJM at Guwahati, my lord. That is how,
But
again, my
you
lord.
are on bail on the. This.
I am in bail in that case, my lord. Kindly consider my lord fear, my lord.
No fear.
No, fear is there, my lord. Then, my lord, if your lordship, my lord,
We may examine your criminal petition.
Yes, my lord.
Grounds which you have
Yes.
in, but no interim.
My lord, then, my lord, lordship will kindly, my lord, allow me one, my lord, prayer to be made before your lordship. Is that, my lord, in that case which has been fixed, my lord, I may be, my lord, allowed to appear through, my lord, VC, my lord.
Why?
That is my apprehension, that if I come to Guwahati from Karimganj, my lord, immediately, my lord, I'll be picked up. That is why I want
In
to
which
show this.
case? In
My
which
lord,
case you will be?
it may be any case, my lord. That is why I want to show the series of cases here, my lord. Your lordship knows, my lord, for the purpose of, my lord, shown arrest, there can be any case number, my lord, shown before the court and a petition submitted that, my lord, I am required to be shown arrested in that case. And those petitions also I have given, and ultimately the orders in those cases also I have given, my lord, to show why, my lord, I am apprehending, my lord. If your lordship kindly takes up, my lord, right from page number, my lord, 26, my lord.
No, in respect of your other peers, we will not go into that. Heard Mr. G. Chaudhary.
My lord, at least give me that amount of protection so that my liberty can be, my lord, maintained, my lord.
No, you make a prayer for dispensing your personal appearance before the court. That prayer you can make.
That may be, my lord, observed by your lordship, my lord, on the basis of your observations.
There is no bar.
I know there is no bar, my lord. At this stage, because I am making a prayer for some interim relief and a lordship is not inclined. Kindly, my lord, give the direction, my lord. That direction may not be an order. My lord, that direction may not be an order, my lord. Kindly reflect that I have made a petition, my lord, and my lord, lordship has left it open to the court below to consider that petition, my lord, under 206, 205, my lord.
No, there is no occasion to pass that.
That occasion I am submitting before your lordship. I am standing and submitting with this set of documents, my lord. Kindly see. Otherwise, my lord, why was it necessary to bring so much on record to establish my case as to how I am sought to be victimized, my lord?
Heard Mr. G. Chaudhary, then counsel for the petitioner. Also heard Mr. T.H. Hajorika, and counsel for respondent number 2, as well as Mr. R.R. Kochik. R.R. Kochik to R.R. appearing for respondent number 1. This criminal petition has been registered on filing of an application under section 482 of the Code of 1908, whereby the present petitioner, namely Nakib Ahmed alias Kanu, has prayed for quashing the proceeding of PRC case number 2085/2021, prayed for the FIR number 247/2021, which has resulted into filing of charge sheet number 67 dated 8/7/2021, on the basis of which PLC case number 2085/2021 has been registered. What are the prayers?
My lord, the prayers for my lord. For my lord, washing my lord. At page my lord 18.
Where is the ground?
Ground starts from my lord page 15, my lord.
Where is your main ground?
The main ground is that, my lord, at page 17, that it's an attempt to convert a civil case into a criminal case, my lord. And thereafter, my lord, at page 16, where I say, my lord, that the IO, while investigating into this case, my lord, failed to prove that the power of attorney by which I claim authority, my lord, was either, my lord, forged or it was non-existent, or that, my lord, that authority was not given to me by the owner, my lord. And the power of attorney is a registered document which has been, my lord, annexed
That
along
you
with the
have to
records.
show in the trial.
My lord,
That ground,
my lord,
I
that
have considered the grounds taken by the petitioner in his criminal petition for assailing the proceeding of PRC case number, for assailing the charge sheet, aforesaid charge sheet, as well as proceeding of PRC case number 2085/. So perusal of the records of the aforesaid case would be necessary for considering the instant criminal petition, considering the grounds taken by the petitioner in the instant criminal petition. Hence, all for the scan copy of PRC case number 2085/2021, along with the scan copy of the case diary of Janmari PS case number.
my lord, perhaps the LCR is here, my lord.
No. A perusal of the case diary of Janmari PS case number 247/2021 would be necessary. No, it is there.
Is the entire material there, my lord? Actually, I have not seen the record.
You will file any objection?
Yes, my lord, after receiving the copy, because I have not gone to the.
Stop. It is the office note dated showing, office note dated 21/11/2022 shows that the scanned copy of the case diary has been received. Stop. Let a report be called for from the trial court as regards the status of the present status of the PRC case number 2 tipo, so and so. Learned counsel for the respondent number 2 has also submitted that he has not received the criminal petition filed by the petitioner, and he intend to file an objection against the same. The petitioner is directed to furnish a copy of the petitioner
By
petition to the
tomorrow.
respondent number 2 by tomorrow. And the petitioner, respondent number 2 is granted 2 weeks time for filing objection against the criminal petition. Though the petitioner has prayed for stay of the proceeding of PRC case number
2085, my lord.
2085/2024,
2021, my lord.
However, after considering the materials on record, this court is of considered opinion that at this stage, this is not a fit case to grant any interim relief. Stop. However, the petitioner is at liberty to approach the trial court if so advised to make any prayer for dispensing with personal appearance of the petitioner before the trial court during the pendency of this criminal petition. Let this case be listed after two.
My lord, kindly, my lord, consider that when it is listed, next, my lord, an effort will be made to finally dispose of this petition.
No, sir. You may let him file objection. What objection he file?
Can it be fixed date be given, my lord?
Yes, suggested date. November 26th. Or first week of December.
As your lordship pleases. Can it be on the 6th of December then?
6th of December.
My lord.
6th of.
I am deeply obliged.
I am deeply obliged.
May I please, Your Honor? No, I'm so sorry. Item number regarding item number 15, Your Honor. I was absent when the matter was called, Your Honor. And
What has happened?
Search submitted, Lord, Your Honor, and interim vacated. Kindly continue the interim till my appearance.
Why were you absent?
As per cause list, Your Honor, the court will sit at 2.
No. Whichever is that. You have to read.
I'm so sorry.
Okay. At item number
15.
Interim may continue.
Till my appearance. Obliged. Deeply obliged.
Interim will continue till your appearance before the trial.
Yes.
What is, show her name of
People.
people. Kajal Titna. Yes.
May please, Your Lordship. It's a application under section 483, Lordship. The petitioner is sole arrested in this case on 18/4/2022. And he is inside the jail for about 2 years, 6 months, 23 days. As of now. So, Your Lordship, in this case, final complaint annexed at page 24. It start from page 24 and 40 is allegation. In the first final complaint when they filed, at that time he was not made accused in this case. So subsequently, supplementary complaint file that is annexure 4, page 41. In this final complaint, this is supplementary complaint. In this, he was made partly accused in this case, Your Honor, because his address was not found and his particulars were not found. Because of that reason,
The final first complaint was filed on
lordship. Somebody here. 17/4/2020. That is page 24. In page 24, it is specifically mentioned 17 within stipulated time. This was filed, and this Sandeep Suraj, Sandeep Kaushik, and Govind Shah. These were the accused person in this complaint. Then, in this complaint against him, there was nothing. Even they have not mentioned in the prayer also regarding this person. Subsequently,
who is the petitioner? Kajal Devnath.
Kajal Devnath. So subsequently in 41, page 41, this is the supplementary complaint. And in this, on the basis of the statement of the accused person or accused person and some mobile contacts which were not in his name, on the basis of that, your lordship, he has made the accused in this supplementary complaint. Then since then he was inside the jail till today, and there were as many as witness list one.
The subsequent supplementary complaint was filed on
This is filed on 29/4/2022. After 2 years of the final complaint.
and you were arrested on 18/4.
Lordship, shown arrested. So
When the 17/4 complaint was filed, cognizance was taken.
no. Against me, no cognizance was taken.
Against other accused persons.
Other accused person, I have no idea, Lordship, because I'm not representing other accused. So in final complaint, 10 number of witnesses cited as witness in their list, and out of 10, 4 witnesses examined. My implication against this cited in this petition at page number 44.
Page number
44. আগত আছে নেকি? আগততো আছে নেকি? May I read it, Lordship?
Yes.
Kajal, alias Kajal Devnath, is the main supplier of this seized of so and the KG Ganja. Sandeep Suraj Singh and Govind Shah admitted this in their voluntary statement. Kajal, alias Kajal Devnath, also admitted that he supplied this seized so and the KG Ganja to Sandeep and Suraj Singh to hand over to Govind Shah or Govind Shah at Madhubani. Kajal, alias Kajal Devnath, is a habitual offender and also accused in NCB crime number so and so with the charge of supplying of ganja from Tripura to other places. Kajal Devnath, in his voluntary statement, stated that he supplied the seized kg ganja to Sandeep and Suraj, and the ganja was destined to Govind Shah, alias Govind Shah of Bihar. He is doing the illegal business of ganja from last 5-6 years, and also no Govind Shah or Govind Shah from last 2 years, and frequently talk with him over telephone and also met with him at Tripura. Kajal Devnath also stated that, this is his statement, one recorded under 67 that he used fake SIM card to conduct illegal business of ganja and not use one mobile number for a long time due to the fear of arrest. Kazal Devnath admitted that he supplied this seized ganja to Sandeep and Suraj, and it means he was in conscious possession of ganja, whose current quantity was much more than the specified commercial quantity. Telephonic communication between Kazan Devnath and receiver Govind Shah, alias Govind Shah, and other accused Sandeep and Suraj Singh have been established from CDR analysis, which corroborates facts of telephonic communication mentioned in the voluntary statement of accused and Kajal Devnath. Kajal Devnath in the voluntary statement stated that he frequently charged his mobile number and also change his mobile number and also use fake SIM for communication purpose. It proved the criminal mental state of Kajal Devnath. That from all circumstances and evidences, it is proved that Govind alias Govind and Kajal alias Kajal Devnath are directly involved in the illegal business of ganja. This is the allegation against the person, and in the main final complaint against him, only the mobile numbers mentioned in paragraph number page number 37. Lordship will find at page number 37 regarding Kajal and a CDR. While these numbers mentioned, these numbers were not in my name. This is not my mobile number. And only on the basis of the 67, which is decided by the apex court in Tufan Singh judgment. And other two case, Lordship, one is pending before the Sessions Judge Kamrup Amingao, and one is before additional Sessions Judge Kamrup Metro number 2. In that two case, he got bail from this honorable court. Apart from this, there is no allegation against this person.
No, when charges were framed,
In this case, charge frame on 5th of January 2022.
but you were arrested on April, in the month of April.
April.
Before your arrest charges.
Charge frame
In your absence.
in my absence on the basis of the final complaint, because I was not made accused in that case.
Then how you were made?
Again, they approached the court, and accordingly, Your Lordship, on the basis of the statement, on the basis of the application filed by the investigating officer, he was interrogated inside the jail and statement recorded there, and he was shown arrested there only.
No, I just
sir.
want to understand.
That
Complaint was filed on 17.
Subsequently, when he again arrested in this case, Lordship, against charge frame against him, I think it is in the record.
Now what procedure is followed?
Permissible Lordship. Supplement.
Let him say regarding procedure. I will come to you.
Can I check the record right now?
Yes. No, just I want to know one thing.
In this case, what happened, Lordship? Initially, final complaint was
Court,
filed on
thank you.
17/4.
Yes,
17/4/2020, final complaint was filed.
against other accused.
He was, he didn't cooperate with the investigation during that time because he was in jail. Thereafter, on the basis, some statement has been made for further investigation. Then on the basis of other investigation, supplement charges was filed on 29/4/2022.
No, no, I just want to understand one basic. Under 36(1)(d), either police report or complaint can be filed.
Lot.
NCP has not gone for police report. It is a complaint.
Complaint.
Complaint has to be under CRPC.
Under the NDPS section 36A.
36. So, but is there any provision for supplementary complaint?
Yes, Lord.
Where?
CRPC is applicable, section 173(8) applicable. So it was filed subsequently, Lord. They have annex also.
No, 173 is applicable in case of police report only.
Lord, it is also applicable in case of
Complaint. Where?
Some judgments are there also.
I want to know that about those judgments.
For today,
Like
I
what procedure NCB is following? NCB is filing complaint.
Lordship for NDPS Act.
NDPS filing negative.
CRPC is applicable.
No, CRPC is applicable, but CRPC prescribes separate procedures for
Complaint as well as.
complaint as well as police register cases.
Lordship for.
If an FIR is filed, how investigation will be carried out? And if a complaint is filed, how the cases will be tried? Now, there are judgments that even in a case filed on complaint by, in case of NDPS matters, the session tribal procedure would be followed.
Yes.
That there are judgments, it is regarding trial only.
Yes.
But where is the procedure where after filing a complaint, you can file a
Supplement charge.
supplementary complaint?
Yes.
In that case. This is one query.
Yes, sir. Page 41, it is stated that an application under.
Because without going into the facts, when the first complaint was filed on 17/4/2020, facts were before you, all the other accused were under arrest.
Yes.
Their statements were before you. Then why cash sheet the complaint Kajal against Kajal Devnath?
No such it was.
No complaint was made at that.
In page 35, paragraph 37. Page 35, complaint, paragraph 37.
Yeah.
The mobile number Sancho, which was being used by Kajal. On analyzing the CA of the said number, it comes to know that it was registered in the name of Sushanta Sarkar.
What is CF means?
Call the details report.
No, that is CDR.
Kuntu CA is a call customer application form.
Okay, customer application.
It came to know that the registered in the name of Sushanta Sarkar. Further, a notice under section 17 of the Act was sent to his address, house number so and so, Tripura, to appear, but his address was not accepted. Then Lordship, page 37, paragraph 53. Paragraph 53, Kajal. That is statement given by Sandeep, son of Fateh Singh. Kajal delivered the seized 24 packet ganja to him. The CDR analysis have been done as under. It may please to see serial number D. Sandeep to Kajal 24 times. Then F. Gobind Kumar Saha to number 22 Kajal 88 times.
No, this number 145 belongs to one Sushanta Sarkar.
Yes, 145. Yes. But it was used by him.
No, that source is that it was used by him. That is the.
That's why Lordship.
No. I just want to understand. The conclusion that it was used by him is on the basis of the statement of Sandeep.
Yes, sir.
Statement of a co-accused.
Yes, sir.
Apart from that co-accused statement, is there any other material to show that it was used by?
This call details was there. His own statement is recorded after his arrest.
No. Don't interfere. He gets disturbed.
Oh, sorry.
So you will get your chance. Let me clarify.
Then Lordship, paragraph 56. The complaint, page 38. Paragraph 56. That from the facts and circumstances stated in foregoing paragraph, it can be established that accused persons.
No, that is a general state.
No, Lordship. Sandeep were arrested under and Sandeep Kochik, Govind Singh, both accounting and Kajal not arrested, have violated the provision of so and so and is liable to be punished under section so and so and presumption under section 35 and 54 reflects against the accused person.
No.
Thus is thereafter
Against, now we are considering the bail application of
Of Kajal.
Kajal.
Not.
So against Kajal, your submission is that material is
because
one Sandeep's voluntary statement wherein he states that from
Kajal
a particular number, Kajal called him 24 times
not.
and Kajal delivered him contraband.
Yes, sir.
This is the statement of Sandeep.
And let's say make page 42, paragraph 3, one word.
Page?
Page 42 is the part of supplement complaint. Married law. Paragraph 3. Page 42.
Yes.
That the statement of Govind Shah, alias Govind So, who was recorded at Bhagalpur Central Jail, and in his statement, Govind Shah admitted that he, along with Sandeep Kochik, fixed the deal with Kajal of Agartala to load ganja and supply it to Madhubani for monetary benefit. He admitted
Statement of whom? Whose
that
statement?
Govind Shah.
Govind Shah is an accused.
Yes, sir. He's an
So
accused.
this is excluded under section 6.
No, Lordship. That I'll address your Lordship.
No, let me examine in that. way.
Yes, Lordship.
Govind Shah's statement is one basis. Then
Yes. Then, Lordship, next paragraph, paragraph 4. That in his statement, Govind Shah also revealed the mobile number of Kajal, that is number so and so. The
Yeah.
same number was also revealed as Kajal's number by Sandeep and Suraj Singh in their voluntary statement. During investigation, it come out that a number of mobile communications held between Kajal, alias Devnath, and Govind Shah. Then paragraph 5. In his voluntary statement, Kajal, alias Kajal Devnath, confessed that he was the supplier of these 243.8 kgs of ganja, and he was sending Singh's ganja to Govind Shah, alias Govind So. Kajal, alias Kajal Devnath, also stated that he know Govind Shah from a long time. Then paragraph 6. Kajal Devnath admitted in his voluntary statement that he know the Sandeep and Suraj Singh, and he supplied 243.4 ganja to them and hand over this to Govind Shah at Punia, alias Bihar. Kajal Devnath also stated that if you use mobile number so and so in 2019-20 and he frequently changed the number mobile number due to fear of apprehension. Detail of mobile communications, because the details is given. Then paragraph 7. The statement of Sandeep Suraj Singh, Govind Shah, Govind So, Atul Kajal Devnath corroborates the fact that all them were engaged in trafficking of 243.3 kg of ganja. Their mobile communications during that period of trafficking also proved the fact that they were in consent touch with each other for trafficking of so and so. And let's say below, the investigation, let's see the role of the present petition has been and Kajal Devnath. Let's see, go to page 44. Kajal Devnath is the main supplier of cheese to 43.8 kg of ganja. Sandeep Suraj Singh and Govind Shah admitted in their voluntary statement. Kajal Devnath also admitted that he supplied cheese ganja 100 kg to Sandeep and Suraj Singh and hand over to Govind Shah at Madhubani. Kajal alias Kajal Devnath is habitual offender and also accused in NCB crime number 6 of 20, 18 of 21 with the charge of supply of ganja from Tripura to other places. Kajal Devnath, his voluntary statement stated that he supplied to seized 2.3 kg of ganja to Sandeep and Suraj Singh and and ganja was destined to designed to Govind Shah of Bihar. He is doing the illegal business of ganja from last 5 to 6 years, and also know Govind Shah from last 2 years, and frequently talk with him over telephone, and also met with him at Tripura. Kajal Devnath is also stated that he used fake SIM card to conduct illegal business of ganja and not used one mobile number for a long time due to the fear of arrest. Kajal Devnath admitted that the supplied this ganja 2.2 43.8 kg to Sandeep and Purat Singh, and it means that he was in conscious possession of ganja whose quantity was much more than the specified commercial quantity. Telephonic communications between Kajal Devnath and Ishwar Govind Shah.
No. One query.
Look.
When the complaint was filed in 17/4/2020 against other co-accused, Kajal Devnath was not named as an accused.
He was not.
What material was collected within after that 2 years, apart from the statement of co-accused?
These are the materials
you-
stated in the supplement complaint.
Supplementary complaint only again the statement of co-accused,
Co-accused and his own state.
nothing else.
Yes, yes.
But that is not admissible.
No, Lordship, regarding Prashant Singh, Lordship, as paragraph 153 says that under section 25, the statement of co-accused are not admissible during the trial, not for the investigation law. And Supreme Court has clarified this position in many judgments. And here, Lordship, another thing in our complaint, in our objection, in paragraph 8.
No. Now, what materials are there to implicate them, apart from co-accused state?
His own
During
statement,
it-
his own statement is there. And,
Is that admissible in evidence?
Lordship, inadmissible, if he fails to produce other evidence, corroborative evidence, then it will not be admissible.
No, but in your complaint, you have to show that you have other evidence.
Yes, that has been reflected.
What are the other evidence?
Yes.
On which your case stands?
What's the paragraph 6? All records.
These statements will give you a lead. Investigating agency a lead to collect the evidence.
Yes,
But this cannot be basis for
No, Lord, if he fails to corroborate all this evidence during the trial, then he will be entitled.
question of corroboration does not arise because these evidence is inadmissible.
No, Lord.
Statement of accused and statement of co-accused are inadmissible.
If
So question of corroborating that does not, this is only a lead to investigating agency. That the investigating agency have to collect some admissible evidence on the basis of these
No, Lord,
leads.
that will come at the time of the trial, at that time of investigation, whether all these things will be considered
No,
by your Lord.
now we are considering, is there reasonable grounds to believe that under section 37,
Then Lordship has to see our objection, paragraph 8, because he was involved in another cases. He is a habitual offender. That is to be considered by your Lordship.
so we will go back to her.
Lordship, let
Your
her complete.
you have to answer one thing, that from 17th April 2020 to 24 April 2022, these 2 years, what material has been collected by NCB apart from the statement of co-accused and the statement of accused himself? Is there any other evidence or material collected which necessitated the filing of additional charge? Because these materials were there in 2020 also, except Kajal Devnath's statement, other materials were there in 2020 also. So what prompted NCB that you can go for his trial? Prosecutable materials, what are the prosecutable materials before NCB? Because they will plead that no reasonable cases against the. So you have to show some material. And one more thing, and provision for filing a additional complaint, like further There must be some provision. Yes, Mr.
That's not there. Lordship, I have to place this judgment. Today I have not already with
No.
this respect of the matter regarding other investigation and filing.
Because I want to know the provision.
Then Lordship, allow
But
me.
let us hear this, because this case is coming
Yes, Lordship, on last occasion,
several occasions.
Several occasions.
I'll address you, Lord.
In this case, Lordship,
What is your main ground for
my main ground in this case, Lordship, in the final complaint, I was not made witness, accused. And my name is mentioned
how
as
many and whether prolonged incarceration is also a ground?
yes. That is also one of the ground, and I was not made accused in the final complaint. And subsequently, I was inside the jail in their case. They could have
Some other case.
some other case, Lordship, see similar nature of case, similar allegation. So in that case, Lordship already granted bail in both the cases. I have annexed. It is annexed 7 and 8. It pays 66 and 78. So in this case, Lordship, except those materials, whichever mentioned in the final complaint, there is nothing. And 67 is not admissible on state, even after made by himself, by the accused, that is not admissible. That is decided by the tax court into punching judgment. So 2 years, 6 months, 23 days is not a minor days. For a longer period, he is inside the jail, and till today, Lordship, only out of 10, 4 witnesses examined. Because we consider that part. He is against him, against Charles Prem on 23. I have flag mark 21/9/23, and we consider all the whatever statement recorded of or deposition recorded by the trial court. We have considered that, but they could not further proceed. And accused from whose position the contrabands were recovered, they got bail.
They are on bail.
Yes. Suraj Singh and this Sandeep, they all are bail. All are in bail. Sandeep and Suraj. Have annexed those documents also, Lordship. It is a page number 48 and 53.
Okay. Finish.
No, Lordship.
Anything? You have anything more?
My lord, this is because section 36 1A for speedy trial, Lordship. And against me nothing, end of the trial, Lordship, what will happen? I will get acquittal, and then, Lordship, these years which I have been inside the jail, that will be nothing, Lordship. For nothing, I will be there. Because they could not establish any case against me in both the 3 cases.
No, we are not concerned with other. Now, this case.
Lordship, in this case, Lordship, I was not made party in the final complaint. Then they could have, because other accused person mentioned the name of Kajal with mobile number. Then they have filed, though Lordship wanted to see regarding the 173A, but they have filed a petition. In that case, Lordship, in the final complaint, they could have mentioned, they could have made a prayer before the court for making him accused in this case. That is not in the final complaint, Lordship. In their prayer. And subsequently, after 2 years, I was inside the jail for in their case. Even after that also, they have not made witness in the accused in this case, Lordship. Subsequently, cognizant starts frame, Lordship. That is, I have tag mark.
Lordship, page 38, paragraph 57.
Page 38 of
Bail
Main
application. There is an explanation. Paragraph 57.
There tonight.
That due to non-receipt of parental address of the suspected Kajal, the said persons could not be made accused at the time of filing of the offence report. If any lead found in the respect of Kajal, the supplementary offence report could be submitted. Then supplement complaint was filed, that were accordingly framed. Now let's may come to our objection notes. Paragraph 8. Page 93.
Okay.
93. Meritor.
Para?
There are 8.
Yes.
That in the bail petition, accused petitioner has contended that there are no criminal incident against him and the period of detention may be considered for granting bail. In this regard, it is submitted that accused Kajal Devnar is habitual offender. Presently, he is facing charge accused in commercial quantity NDPS case booked under NDPS Act number so and so. When case number has been given. Further, as on date, 4 prosecution witnesses have been examined and only 6 prosecution witnesses are to be examined. Then we have cited some judgment. I'm citing one other judgment. Honorable Supreme Court in the case of Ajit Singh versus Inderpal Singh. Reported in 2021, 19 SCC page 355. Paragraph 7, 8, 9, 11, 12, and 13.
2021, 1980.
I'm giving the page now.
Page 3.
I'm giving the copy lot. 2021, 19 SCC page 355.
What it says?
It says that when the an accused in habitual offender, court should not grant bail. This is the law.
No.
Yes, sir.
No.
Yes,
I'm not disputing. I'm not saying no to that.
Acha.
Question of habitual offender will come secondary. First, you have to show that the case in which he has been charged, there are materials.
Yes, sir.
First, in this case, you have to show that there are materials.
Actually, the supplement complaint is there itself speaks, and thereafter charges been framed by the learned trial court. Previously finding that there are critical material, which also establishes that charges are against me. The learned trial court would not have found any materials, not have framed charge against me.
No, okay, that is one submission. And as while considering a bail application under NDPS, court has to consider whether there are reasonable grounds to
proceed against it.
To find out whether he is guilty of the offense charge. We can go into the material. Therefore, my query was, what are the materials on which your case stands? But you have shown only 160
supplement complaint.
Supplementary complaint, which is based on statement of accused
and
as well as
co-accused. And all records collected by the
call records of phone number which is not in his name.
But he admitted that he used that number.
That is again under 67 E.
No, Lordship, but Lordship is to consider that we cannot find out any direct evidence in case of NDPS because these are the organized crime.
No, that will not help NCP.
Lordship, that will help. Supreme Court is many judgment has considered this in Hira Singh. Supreme Court has made a specific statement to that.
You have to find admissible evidence to convict a person.
No, Lordship, that is in the trial. That is my submission. If the agency fails to prove that, then he will be entitled to. But and during that investigation, and filing the complaint, okay, whether we can, but there is an obstacle by created by the Honorable Supreme Court by Tufan Singh. But,
Not obstacle. This is Supreme Court has laid down the law
no, Lordship.
that what is admissible and what is not.
No, Lordship, may please do. There is a judgment. There is an dissenting judgment also. That although this is not admissible, but that is also important to look into. What observation is made in that part of the judgment law.
But as on date, the law is that
Yes, Lordship, in page
you cannot base your case on the basis of statement of co-accused.
that is only during the trial. That has been carried by Supreme Court in.
No, yes,
Massachusetts.
I am also trying to say that statement of co-accused will give lead to the
Investigation and
agency,
filing the complaint.
not filing the complaint, to finding out other admissible evidence on the basis of which they will have
Then
to file complaint.
Lord-
If they don't file, do labor and find out other admissible evidence, then file the case on the basis of inadmissible evidence. The fate is well known. What will be the fate of such cases?
But Lordship, in case of NDPS, what agency will do? Then they have to let out all the accused persons.
No,
Then where is the answer available?
lot can be done.
And recently, in one case, Lordship, they have not brought that judgment. Calcutta High Court.
Now what NCP is doing, NCP is filing a charge complaints on the basis of inadmissible
No,
evidence.
Lordship, we are
So after
now,
many years of trial, the fate is acquittal. It is resulting in acquittal.
Lordship, on only technical ground. Only on technical ground. My learned friend knows because he is also conducting trial in many cases. On the technical ground, court is bound to acquit the accused person.
What is meant by technical ground?
Technical ground that not following the procedure as per the. law.
You have to follow the procedure.
Yes,
therefore.
Lordship, there is an argument because I think it is in division based one matter is pending, probably on 14 it is fixed. Lordship, what happened, there was a notification called 1 of 89. NCB and others.
That is another aspect that should not be brought right now because that
No, I am
should be
ju- I'm
disclosed
just-
right now.
I'm
Already
not-
Lordship decided in another case to that regard.
There are many, I have made.
Already
arguments that
decided
this
on
honorable
court,
court is to
Lordship
consider
declared
that,
the judgment.
only on technical grounds accused are being acquitted. Lord.
Not only,
And
we are conducting the trial. He has stated that we are conducting trial. We
Also,
admit that, but not only in the technical grounds.
Interestingly, the NDPS crimes are organized crime. Lord.
And therefore a national level investigating agency has been created.
Yes, Lordship, that's why now.
And you
Lordship,
cannot show your helplessness that we cannot follow the established law.
Lordship, it is not.
And you are filing the charge sheet on the basis of inadmissible evidence.
No, this is the, no, Lordship, I'm not saying that we are filing complaint on inadmissible evidence. Proper investigation, the complaints are being filed. And the accused are being acquitted only on the ground of technical ground. And Lordship knows these are the organized crime. Only those persons who are being arrested from whose position the contraband are seized. And after Tufan Singh, Lordship, the agency has no, they are bound to let off all the accused persons against whom only statements are being made by the co-accused.
Because you fail to collect other evidence.
Lord, is it not possible also, Lord?
No, don't say that it is not.
Yes,
possible.
Lordship, because I am.
This would only reflect the incompetency of NCP. If you say
No.
that you are unable to collect the evidence, admissible evidence,
This is the reality, Lordship. This is the reality.
that the NCP is incompetent.
Not NCB is incompetent because
Then-
evidence are not being, because Lordship, who will admit? And when a person is admitted, he will not be prosecuted.
No, admission is not.
Now, suppose Lordship, one truck is carrying ganja. The drivers and handymen are being arrested. They say that these goods are loaded by some other person. As soon as we arrest this person, they will be let out on the basis of Tufan Singh's statement, judgment. Lord.
Because Tufan
Tufan Singh
Ed-
says that
statement under section
it is not
67 is
admissible.
not admissible.
Earlier
You have to understand.
Earlier it was admissible.
Now you have to understand the law. NCB has to understand the law that
Yes, Lordship, because
on the basis of inadmissible evidence, you cannot build up your case. You have to collect evidence which is admissible in trial.
in that case only, Lordship, the persons from whose position of contaminant means they are being made accused. Because Lordship knows this is an organized crime.
Okay,
Lord-
in this case, what else is your objection regarding prolonged incarceration?
Lordship, in my humble submission, because he was arrested.
Soon arrested.
2022,
Mm.
whatever it may be.
Mm.
Then Lordship, supplement complaint was filed on 29/4/2022. Then charge against him was framed, and PW1 was examined on 24th of February 2022. Then
PW1
last witness PW4 was examined on 19/8. That means our objection we have clarified. My
your
main
objection
content,
you have mentioned.
yeah, date has not been mentioned, but we have mentioned that 4 out of 10 for PWs have been examined. Now, our main contention with your Lordship is that he is a habitual offender. In same type of offense he was earlier arrested, although he was granted bail by a Lordship. But
In other cases, he is on bail.
he is
Yes.
granted bail by, that has been annexed here. But that cannot
I have
be,
annexed, Lord.
but that cannot be a ground in my humble submission.
Okay.
And again, after getting bail, Lordship, he will be involved in such type of business and is an habitual offender. And I'm supported by the judgment case before. Regarding procedural, Lordship, allow me, I'll address you and place the necessary judgment on.
No, I'm fixing this for order. You may reply to my, because this is general query,
Yes, yes,
not regarding this case. That where is the provision for supplement
I'll
complaint?
Yes, I'll address your Lord. Because that power has been given by the Supreme Court.
I just want to know the law.
I'll put it. In other case, I'll address your Lord.
Third, Ms. Skinner gets done counsel for the petitioner. Also heard Mr. HCKR, then an additional public prosecutor. And then it, Mr. HCKR, learned standing counsel for NCB. Let this case be listed for delivery of order.
Monday 18.
On 18th. You also answer my one query. In other cases, we will face each other on many other occasions. Suppose an innocent person is made an accused on the basis of statement of co-accused person without there being any other evidence. What protection is there to him, and what is the difference between him and persons like Kajal Devnath, whose case, who you are saying that he is a habitual offender, but against whom also you don't have any other evidence except the statement of co-accused.
Or is it?
What is the distinction between,
I'll
the court will differentiate between an innocent person and a person whom NCB is saying that he is an habitual offender?
I'll address your Lordship with support of some authorities of the Honorable.
In some other case.
Yes, Lord.
This case is fixed for delivery of orders on 17th.
Lord,
Okay.
Earlier, Lordship granted bail. I have annexed. It is in my briefing.
I'll address your Lord.
I add up all the citation, Lordship, to whichever relied in this judgment, and one more I am doing commitment. Published.
May it please, Lordship. Lordship, this is the anticipatory bail.
application. And the Lordship, can you come to the page number 12, vernacular of the FIR?
What is the offense?
Okay. Offense 103, murder.
Oh,
Murder.
case diary is there.
No,
No, this is the motion.
for motor not.
Lordship,
103. What is your case?
Lordship, actually, I am the petitioner number 4 and 5. I am petitioners here.
You are named in the FIR.
Yes,
Bilal and Nur Jahan.
Bilal and Nurjahan, accused number 4 and 5.
Okay.
So, and the
It is
accused number 4
required.
is the brother of the main accused, Mainul Haq. And accused number 5 is the wife of the main accused. And main accused, namely Mainul Haq and Ainul Haq, both the brothers, and they have surrendered already before the court, Nagaon court.
They are arrested.
They are not arrested, surrendered
Now they are in custody.
in custody. They are the main accused. But accused number 4 and accused number 5, that means the present petitioners are the brother and the wife. That's why they have falsely implicated him. So actually, the petitioners are not involved in this case.
Case diary would be required. When they
Lordship, at least, may can be given interim protection, Lordship.
No, but FIR was filed in the month of September. For more than a month, you have approached this court after. You have approached any other court? Sessions court?
No, Lordship.
Directly you are approaching. this.
Directly.
Case diary would be required.
Lordship, at least the lady, the second petitioner.
But against lady also there is a
Yes, Lord.
allegation. Number 5.
Accused number 5 is the lady. Lady was not involved in that case.
Well, a specific allegation is there. 1, 3, 4, 5. Atamir Rasta Laguchi 3 Sukas for a Musami Putok.
Yes, therefore case diary. We are putting a short.
May can be fixed on 14th, and the another AB, this is 2791 is fixed on 14th of this month.
Case diary has been called in that
Yes,
case.
yes, definitely. But up to date,
Okay.
see,
Heard Mr. M. Rahman, learned counsel for the petitioner. Also heard Mr. R. Kaushik, learned additional public prosecutor. This application under section 482 of BNSS 2023 filed by the petitioners who are apprehending their arrest in connection with Rupohir PS case number 278/2024 under section 61 within bracket 1 within bracket small a /118 within bracket 2/109/126 within bracket 2 of BNS 2023 with added section 103 within bracket 1 of BNS. So, considering the nature of allegations leveled in the FIR, perusal of the case diary would be necessary. Hence, call for the case diary. Please, this matter.
up to date case.
Up.
The 2 persons are arrested, and the new thing may come.
No, we are calling for the first time. So it is assumed that case diary would be up.
So already CD is available in the court for 14th of April, another bail application out of the same.
It is available in the court.
Yes, sir. Court number 10.
don't know. I don't know if any
Today was fixed, but it has been, they have taken time for 14th of
For producing updated case diary.
Lordship.
Okay, let us see.
That is better be tagged with the petition.
Maybe we take.
No, it registry will do that.
Right.
Let this case be listed again on 14th
With case number AB 2791.
with case number AB 2791
of
2000.
Obliged.
One letter judgment is that 2022 to Supreme 409. In this 67 grant of bail challenge to no substantial material was available with prosecution at the time of arrest to connect respondent with allegations level against them.
2022.
Yes, but I'm submitting this.
Okay.
It is
The earlier case,
in earlier case.
Kajal Devnath.
Yes, exactly our case.
No, still say the citation 2022.
It's in Supreme today, Lordship.
What is this
Uh,
party's name?
Parties Pollulobit Ahmad, Arimutta, and others. I'm submitting this.
Harimutta.
Yes. Let's see, 2
This case was referred,
2022,
this
12
case was
SC.
referred by Mr. Kyle in many cases. Something in favor of NTP is also there.
Something is there. EDR and all. It is reflected, it is cited in 2022 12 SC 633. I'm highlighting this. Like,
Itu Kajal Devnath.
My pleasure, Lordship, for a bail application, FIR is stayed, Lordship. Allegation under section 103, 60 days behind the bar, Lordship.
What is the allegation?
Allegation under section 103, Lordship.
No, that is the section. What
Murder.
has been alleged?
Murder.
What has been alleged? Read the FIR.
FIR is stayed, Lordship.
How many petitioners are there?
3, Lordship.
What are the names?
Name
Sujan,
Sujan, Ranjit, and
Ranjit,
Kamal.
and Kamal.
Yes, Lordship. I peruse the FIR.
Yes.
With due respect and humble submission, I beg to state that on 14/8, Lordship, which is typographical mistake, 14/8, at night about 11 PM to 12 noon, 12 AM, my elder brother Shahjahan Ali, so and so, died prematurely under a heart on the pond of Jaladhar Malik. Later we come to know from a postmortem report of my brother that my elder brother did not die. He has been killed, and the above mentioned accused is involved with my elder brother's death. Because the accused number 1 told to Jaladhar Malik that you won't let people come through your pond, otherwise big accident may happen, and then you can be in any danger. And also told that Shahjahan has stolen the Sujan's lost mobile. There was quarrel between my elder brother and the accused number 2, 3, 4, and 5 at Diprang Bazaar.
Is there any vernacular affair?
Vernacular affair, page 15, Lordship.
Read vernacular.
হনুমানপূর্বক বিনীত নিবেদন এই যে জোয়া 14/8/2024 তারিখে ৰাতি অনুমান 11-12 মান বজাৰ ভিতৰত মোৰ দাদা শাহজাহান আলী এটা টালি ঘৰৰ তলত অপঘাতী মৃত্যু হয়।
Who translated the affair?
One of my friend.
He has mentioned wrong dates in the translation.
Yes, typical mistake. There is a typical mistake, Lordship.
Yeah. Continue reading vernacular.
মৃত্যু হয়। পাছত মোৰ দাদাৰ মৰণোত্তৰ পৰীক্ষাৰ ৰিপৰ্টৰ পৰা জানিব পাৰিলো যে মোৰ দাদাৰ অপমৃত্যু হোৱা নাই, হত্যা কৰা হৈছে। আৰু মোৰ দাদাৰ হত্যাৰ লগত উল্লেখিত আসামী কেইজন সম্পূৰ্ণৰূপে জড়িত আছে। কিয়নো 1 নং আসামীজনে জলধৰ মালিকক কৈছিল যে তোৰ পুখুৰীৰ পাৰেৰে মানুহক অহা যোৱা কৰিব নিদিবি, কেতিয়াবা ডাঙৰ ঘটনা হ'ব পাৰে। তাৰ পাছত তই কিবা বিপদত পৰিবি পাৰ। আৰু কয় যে সুজনৰ হেৰুৱা মোবাইলটোত শাহজাহানে চুৰ কৰিছে। এই মোবাইলৰ চুৰি হোৱা বিষয় লৈ দিপ্ৰাং বজাৰত মোৰ দাদা শাহজাহান আলী আৰু 2, 3 আৰু 4, 5 নং আসামীৰ লগত কাজিয়া সৃষ্টি হৈছিল। বজাৰৰ মানুহে কাজিয়া মীমাংসা কৰি সকলোকে ঘৰত পঠিয়াই দিয়ে। মোৰ দাদা ঘৰত যোৱা পাছত আকৌ 2, 3, 4, 5 নং আসামীৰ লগত ফোন যোগে কাজিয়া সৃষ্টি হয়। মোৰ দাদা ফোনত কাজিয়া কৰি 8-9 মান বজাত ৰাতি ঘৰৰ পৰা ওলাই যায়। দাদা বহুতো সময় ঘৰত নহওঁ। পত্নীয়ে বিচাৰি নোপোৱাত আমাক ফোন যোগে জনায় যে দাদা এতিয়ালৈকে ঘৰত অহা নাই। পাছত অনুমান 11 আৰু 12 মান বজাৰ ভিতৰত ৰাতি মোৰ দাদা মৃতদেহটো জলধৰ মালিকৰ পুখুৰীৰ পাৰৰ এটা চালি ঘৰৰ তলত পাওঁ। Yes, hard, near the pond of Jaladhar Malik. The incident took place on 14/8, but affair lost on 12/9. After 1 month, and the disease was found near the pond of Jaladhar Malik, which is 4 kilometers away from the house of the accused petitioners. Even the accused petitioners do not know the Jaladhar Malik, who is Jaladhar Malik, Lordship. And all the accused petitioners and the disease were drinking wine at Diprang market. where the accused petitioner one's mobile handset was lost, lordship. After drinking, the deceased left the place before them. Thereafter, they were searching the mobile phone, but not found. Then the accused number 2 rang the deceased, and some altercation took place over phone. Thereafter, they
Between whom?
between the deceased and the accused number 2, lordship.
Dilip and Dilip.
Accused number 2, Ranjit, I think. Accused petitioner number 2, Ranjit.
Okay.
Then they complained about this to the deceased elder brother at Deepram market and left away. This is the fact, lordship.
So there was an altercation at the stand of
You have taken my phone. Give me return my phone.
only telephonic conversation.
Telephonic conversation, yes, lordship. And the deceased dead body was found near the pond of Zoladar Malik. And there
What is the postmortem report says?
Postmortem report says
Cause of death?
antemortem ligature strangulation.
Strangulation is there. Oh. The case of murder is
Yeah. Apparently, my lord, they had a quarrel, these petitioners and the accused. Sorry, my lord, deceased over a mobile theft matter.
Actually, main
And my lord, subsequently, this dead body was found on near this pond. And that particular day also there was a altercation over phone.
now nothing, no lead,
Directly,
no evidence could be
here.
yet collected.
But altercation
Still a
between-
strong suspicion is still
suspicion is
there. How many days you are behind the bar?
60 days, lordship, as in that. They are innocent, lordship. They are no way connected because they quarreled on mobile phone, lordship, at in the evening, lordship. And the main quarrel took place between accused number 1, he is Jafar Ali, lordship. And he warned the Zoladar Malik, not by the present accused petitioner, lordship.
Jafar Ali is also behind the.
No, I'm not paying for bail. The accused petitioner's
Where is
number,
Jafar Ali?
he's in
He's not
detention.
behind the bar.
He's not arrested.
He's not
He's arrested here.
Jafar
I have not filed for him.
Yes, Mr. Kaushik. What is your?
Lordship,
Why not, although there is no direct implication is here, evidence so far, but the events leading to the death of the person, my lord,
There was a quarrel between
because
accused number 2 and petitioner.
with all the experts,
no,
there was a altercation.
they were present when the altercation took place. Lordship.
As a witness, my lord, with all the
Lordship, main quarrel took place between Jafar Ali, lordship. Jafar Ali and the deceased, lordship. You know, lordship, kindly come to page number 15 below fourth line. You know, এক নং আসামি জনে জলধর মালিকক কৈছিল যে তোর পুখুৰীৰ পাৰেৰে মানুহক অহা যোৱা কৰিব নিদিবি, কেতিয়াবা ডাঙৰ দুৰ্ঘটনা হ'ব পাৰে. He warned the জলধৰ মালিক, lordship, not by us, lordship. আৰু তাৰ পাছত তই কিবা এটা বিপদত পৰিব পাৰ আৰু কয় যে সুজনৰ হেৰুৱা মোবাইলটো সাজানে চুৰ কৰিছে. Kindly consider the length of detention,
I would like
60
to pray
days.
for some more days, my lord, because investigation is going on.
No, but nothing is there. Something has
The
to be.
suspicion is there.
Apart from suspicion,
Yes.
suspicion however strong. Some material, even if
That is what
there is some weak material, but no material is there. Except the fact that there was a telephonic argument.
Yes. 60 days behind the bar.
We'll direct them to appear before IO every week for once
Very
in
calm.
once in a week for next 4 weeks.
Yes, Lord, under any terms. R.A. Ahmed.
Mr. R.A. Ahmed, Senate Counsel for the petition. You have gone through the case diary, na?
Yes.
Also, Mr. R.R. Kaushik, Senate Counsel for Senate Additional Public Prosecutor. this application under section 483 of BNSS 2023 has been filed by the petitioner, namely Sujan alias Sujan Bhomik, number 2 Ranjit alias Ranjit Malik, and Kamal alias Kamal Majumdar, who are detained behind the bars since last 13/9/2024 in connection with Mayong PS case number 97/2024 under section 61 within bracket. What is 61?
Criminal conspiracy.
61 within bracket 2/103 within bracket 2 of PN. The gist of accusation in this case is that one Saddam Hussein, who is the younger brother of the deceased Shah Jahan Ali, had lodged an FIR before the officer in charge of Mayam Police Station on 12/9/2024, on 14/8/2024 at about 11 p.m. to 12 noon. No, 14/8/2024 at night, the elder brother of the first informant was found dead in a thatched hut near the pond of one Jaladhar Malik. So it is stated in the FIR that later on the informant came to know from the post-mortem examination report of his younger brother that he did not die a natural death, but he was killed. And it is suspected that the accused persons involved in the present petitioner are, including the present petitioners, are involved in the killing of the brother of the first informant. So it is stated in the FIR that the accused number 1 named in the FIR, namely Jafar Ali, had told one Jaladhar Malik not to allow people to come through his phone, as he will be in danger, as otherwise he will be in danger. He also told Jaladhar Malik that the deceased Shah Jahan has stolen the mobile phone of Sujan, namely petitioner number 1.
Yes.
That is the petitioner number 1. Stop. Learned counsel for the petitioner have submitted that the allegations leveled against the petitioners in the FIR are not true, and petitioners are arrested only on the basis of suspicion, without any basis of mere suspicion. Stop. It is also submitted by learned counsel for the petitioners that on the date of incident, there was a quarrel between the deceased and the accused person at Diprang Bazaar regarding the stolen mobile of petitioner Suzanne. However, thereafter, there is no other evidence which suggests no other evidence on record which suggests the involvement of present petitioner in the alleged offence. And counsel for the petitioner has also submitted that the FIR has been lodged after a delay of 1 month and nothing has been mentioned in the FIR to explain the delay. And apart from the suspicion, there is nothing on record. It is also stated, submitted by learned counsel for the petitioner that the dead body of the deceased was found near the pond of one Jaladhar Malik, and the said place is how far?
4 kilometers away.
4 kilometers away from the residence of present petitioner. Learned counsel for the petitioner has also submitted that the petitioners are detained behind the bar for last 60 days, and considering the period of detention, they may be allowed to go unpaid. He also submits that the petitioners are ready to cooperate in the investigation if they are allowed to go on. On the other hand, learned additional public prosecutor has produced the case diary of Mayong PS case number 97/2024 and has submitted that on perusal of the postmortem examination report, it appears that the death of the deceased Shah Jahan Ali was not natural and ligature mark was found on his neck. So the learned additional public prosecutor has also submitted that there was an altercation between the accused persons and the deceased on the date of alleged incident over the allegation of theft of mobile of Sujan Bhomik by the deceased. Stop. He submits that though at this stage of investigation, no direct evidence could be collected, however, materials on record suggest that there is a very strong suspicion pointing towards involvement of the present petitioner in commission of the alleged offence. I have considered the submissions made by the counsel for the petitioner as well as the additional public prosecutor and have gone through the case diary of Mayam case number 97/2024. Though from the postmortem examination report, it appears that the deceased Shah Jahan Ali died due to strangulation and ligature mark was found on his neck. However, apart from the fact that on the date of incident, there was a quarrel between the deceased and the petitioners at Diprang Bazaar over theft of a mobile phone. No other material are there at this stage which implicates the present petitioner in the alleged offence. Stop. Though there is a strong suspicion against present petitioner regarding their involvement in the alleged offence. However, suspicion, howsoever strong, may not take place the- may not substitute the place of evidence. Stop. Moreover, considering the fact that the petitioners are detained behind the bar for last 60 days, this court is of considered opinion that if the petitioners cooperate in the investigation, their custodial detention may not be necessary for their completion of investigation of Mayam case number 97/2020. So, in view of above, the above named petitioners are allowed to go on bail of rupees 30,000 each with one surety of like amount subject to the satisfaction of learned Chief Judicial Magistrate Morigaon with following conditions. Condition number 1 and 2. Number 3, the book. All the above named petitioners shall appear before the investigating officer once in every week for next 4 weeks or till the investigation is completed, whichever is the earlier, and cooperate in the investigation. So, with above observation, this bail application is set back.
Nice.
Ma'am, this appeal is already admitted, Lordship, on 1/5/2024. We can have there is the order.
Why it has come?
Lordship. Then subsequently, we have taken steps and report is there in respect of informant Lordship. Second file.
It is a POCSO case.
POCSO case, Lordship. Service in respect of informant Lordship. Second file, SR flag mark is the service report from the NDPS. And additionally,
This is a POCSO.
Lordship.
Okay. Heard Mr. M.K. Hussain, learned counsel for the appellate. Also heard Mr. R.J. Mr. R.R. Kaushik, learned additional public prosecutor. It appears from record that though this appeal has been listed in admission column, however, this appeal has already been admitted by order dated 1/5/2024. So it also appears that the records of trial court, the records of special POCSO case number 52/2019, which was requisition from the trial court, have already been received. Notices were also issued to the POCSO. You have issued dusty service.
Hotel out, Lord. But additional services.
You cannot face the victim.
No, that not for not that reason, Lordship. Normal as usual process to also, Lordship. There is report to CJM also.
Through CJM also.
Lordship. Yes, sir. Yes, sir. Mark, Lordship. Second file. Yes. Flag mark as yes, sir.
Second file. I have perused the report of service of notice received from service of notice on respondent number 2 received from Chief Judicial Magistrate Golaghat. Stop. The notices are therefore held to be duly served of the respondent number 2. None has appeared for respondent number 2. As the case involved, as the case involved offense, as the instant appeal involved offense under POCSO Act, this court is of considered opinion that an amicus curiae may be appointed for defending the cause of the victim in this appeal. Mr. Nawaz, you are in the list. You defend the cause of the victim. The Mr. Sarfraz Nawaz is who is empaneled in the list of amicus curiae prepared by registry of this court by notification number 23 is hereby appointed as amicus curiae to defend the cause of the victim in this appeal. The registry is directed to paper book would be necessary.
All in English.
Registry is directed to furnish necessary papers. Memo of appeal you furnish
I'll fund it. I'll fund it.
papers to learned amicus curiae. The learned counsel for the appellant shall furnish the memo of appeal along with the annexes to the amicus.
I have also lordship. I asked for deliver. I have
Let him go through.
5 years lordship. Convictions already 8 months gone.
No, still let him go through.
Lordship.
In in view of the appointment of amicus. No. In I also like heard Mr. NDPS. Learned counsel for the applicant as well as Mr. R. Kaushik, learned additional public prosecutor. So, in view of the appointment of amicus, Mr. Sarfaraz Nawaz as amicus to defend the cause of the victim in the connected appeal. Interlocutory application shall be considered on the next date so that the learned amicus curiae may go through the record before it makes. Let this case be, let the appeal be listed for him. Appeal or appeal be listed for hearing.
Maybe for order lordship. I is there lordship.
Okay. We can hear the matter.
Yes,
it is a POCSO matter instead of
otherwise 5 years conviction 8 months gone.
you. What is your case? Is it a strong case or a weak case?
Case. We may be,
Your case is a weak case.
I have a strong case. I have to acquitted.
You have a strong case.
Strong case. Only circumstantial evidence.
Then his case is weak case.
Better perhaps.
Then let us hear the appeal.
Then
Let it come in order. Let this case be listed in orders column of. On that day, we will finalize the date for hearing. Orders on 21st.
May I please your lordship? This is an appeal
This is an appeal, Your
First time.
Lordship. This is an appeal against the order and judgment at 7/11/23, whereby the appellant was convicted under Section 307 of the Indian Penal Code, and thereby sentencing him to undergo an imprisonment of 5 years and pay a fine of 20,000, and in default, additional imprisonment for 1 year, Lordship. Now,
Heard, Mr.
Lordship, there is a IA pending with regard to a delay. There is 121 delays.
There is a delay.
Lordship, 121 days delay in this matter, Lordship. I'm appearing as the legal aid counsel in this case.
Then we'll issue notice.
Lordship.
We'll heard Mr.
M.K. Das.
M.K. Das, done it. Legal aid counsel in Ion, done it. Legal aid counsel preparing for the applicant. This
Proceed. Yes, in this case, notice was issued already on 25/10. As per my note.
no delay has been condoned.
Lordship.
Delay has already been condoned.
Sorry,
So in main appeal, this appeal has been referred. This is a jail appeal.
Lordship.
This appeal has been preferred by the applicant. Appellant Babu Ray, impugning the judgment dated 7/11/2023, passed by the Court of Law and Second Judge Chirag in Sessions Case number 7/2021, whereby the appellant was convicted under Section 307 of the Indian Penal Code and was sentenced to undergo rigorous imprisonment for 5 years and to pay a fine of 20,000, and in default of payment of fine to undergo simple imprisonment for one year. Issue notice to the respondent. Since none additional public, Mr. R.R. Patrick, none additional public prosecutor has appeared for respondent number 1. No formal notice. As regards respondent number 2, the appellant shall take steps for issuance of notice by a registered post as well as the legal mode within 7 days from the date of this order, returnable after 1 month.
Let me, Lordship, the registering direct to take the steps as per the legal aid.
What is the procedure?
Usually, Lordship, the registry is directed to take the steps with regard to legal aid cases.
Or you may take steps and you can submit your. Okay.
Required.
Registry shall issue notice to the respondent number 2. This appeal is admitted. All for the records of second case number 7/2021 from the trial court. The registry to issue requisition. Registry to take steps for requisitioning trial court records.
So there's a IA with regard to suspension of sentence and for allowing.
After receipt of the I applicable heard heard Mr. M.K. Das, legal aid counsel, appearing for the applicant. This application under section 389 slash 389 of Code of Criminal Procedure number 1973 has been filed for suspension of sentence imposed on the applicant by the impugned judgment by the Court of Learned Session Judge Siraj Adarkar. Stop. The applicant has impugned the judgment dated 7/11/2023 passed in Sessions Case number 7/2021 in the connected appeal. In bracket, Criminal Appeal number 369/2020. The trial court's records have already been requisitioned. No, in the in the appeal, a direction have been issued to requisition the trial court record. This interlocutor application shall be considered after receipt of the trial court record. List after court.
Deeply.
What is it?
We were discharged in a case, my lord, against this complainant has come in division. We were the accused persons in CR case number 74 of 21. Since it was exclusively triable by the Court of Sessions, it was committed. Subsequently, my lord, discharged. Page 24 is the discharge.
Yes, what is the case?
My lord, in this case, complaint was filed before the CGM test board.
No, what is the error in discharge or order?
My lord, first of all, case was committed to the learned session court and the learned session court was hearing this case on committal. So, my lord, the learned session court has altogether discharged all the complainant, all the accused persons with the disregard of the, my lord, evidence that the accused, that is number one accused is Asad Ali. He had kidnapped my minor girl and raped her. Thereafter, a compromise, it is, my lord, a agreement was there that when my victim girl will attain the majority, then that accused person will marry her. Thereafter, again, my lord, my minor girl was in my custody. Again, he, after some days, he kidnapped her. Again, he raped. And thereafter, my lord, my minor girl was pregnated by the accused one.